Right, a fiscal note, a bill schedule for hearing,
Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, February 5th, 2025. We have 12 bills on the docket, and we're going to start off with Senate Bill 466. Mr. Attorney General, welcome.
Just for clarification, am I on a clock? I won't be long, but am I on a clock?
The general is never on a clock in the Judicial Proceedings Committee. No, you're elected official. No, you're not.
Well, I'm glad to hear I'm never on the clock, and I also never leave the office without my subject matter experts. I'm joined by Zach Shirley, who is the director of the Medicaid Fraud and Vulnerable Victims Unit, and he should be no stranger to you. Before I launch into my testimony, let me say that this is the unit that not only safeguards and protects our huge resource in the Medicaid program, but this is the unit that protects our vulnerable victims, whether they reside in nursing homes, assisted living facilities. And I want to start by thanking you for at least the last 2 sessions. You've given us greater tools, greater resources to do that important work. So thank you. Chairman Smith and members of the committee, certainly an honor to be able to present Senate Bill 466. Vulnerable and senior adults. If you're reading the base bill that was filed, please discard it. The bill has been amended in its entirety from top to bottom. The intent, the purpose of the bill has not been changed. And as Mr. Shirley will mention, working with bill drafting, and we all know the volume of work from bill drafters, it just didn't come out right. So the amendment really is just clarifying the language that was intended to be in the bill. So I want to thank you for the opportunity to testify. Senate Bill 466 is about trust and accountability. Our elderly and vulnerable adults often depend on caregivers, family members, household members for essentially daily needs, and that's whether it's bathing, dressing, or preparing meals. For many, this care is not optional, it's a necessity. And that dependency creates an inherent power imbalance, one that bad actors can exploit. So Maryland law already recognizes that vulnerable adults deserve additional protections. You can look at the separate crimes for abuse or neglect of a vulnerable adult. There's a separate crime for called financial crimes against vulnerable adults. These laws reflect our understanding that crimes against vulnerable adults are distinct from ordinary theft or assault. The problem is that our current financial exploitation law is too narrow. Today, the law focuses on how the crime occurs, and it requires proof of deception, intimidation, or undue influence. And this ignores the reality of the relationship between caregiver and vulnerable adults. And I'm going to take the risk of giving an example of in my own case, right? And by no means would I ever exploit my 97-year-old mother, who is an independent liver. But she relies on me to help her with the small sum of money that she had that my father left her when he died. She relies on me to set up accounts, whether it's for her credit card or her online grocery shopping, which she can all do herself. But she relies on her son and trusts me in doing this. Someone in my position could easily divert funds from my mother's account into my own account. And there's no deception, there's no manipulation, and there's no intimidation. And now when my mother's account is drained and one of my siblings finds out, by God, what did you do? and they come to the Medicaid Fraud and Vulnerable Victims Unit, we say, hey, you know what? That's a bad situation, but we can't prove deception, manipulation, or threat. So we're asking to change the law. And we're asking to change the law so that when someone in that position of trust misappropriates money for them to the disadvantage of the vulnerable adult, that we can hold them accountable. Supreme Court in Maryland has spoken to this. Supreme Court has looked at our law and said, yes, you've got to show deception, manipulation, or a threat. So we've also seen it firsthand. And Mr. Shirley could certainly run you through a number of cases that we've seen. I'm not going to run you through those. So we have a Senate Bill 466, as I mentioned, with amendments from title to the end that we believe fixes this issue. It shifts the focus from how the crime happens to who the victim is and the reality of their dependency. Prosecutors will be able to charge a caregiver, family member, or household member with an exploitation offense in addition to theft. Courts can then sentence accordingly, recognizing that it's not just theft, but a breach of trust that makes these crimes especially harmful. Critically, this bill does not change or create new definitions for caregiver, family member, or vulnerable adult. The General Assembly has carefully considered who these actors are. You've put definitions in the law, so we're really building on existing law. And importantly, a conviction under this bill, if adopted, results in a mandatory exclusion from federal and state-funded health care programs, which doesn't exist today. If you exploit a vulnerable adult under your care, you should not be allowed to continue working in the health care system. And this ensures that bad actors are removed from positions where they could harm others. So the bottom line is the bill strengthens protections for our most vulnerable residents. And for these reasons, I, as the Attorney General, the Office of the Attorney General, as well, urges a favorable report on Senate Bill 466 with that very important amendment, which really is the bill. Thank you, and I look forward to any questions that the committee has.
Good afternoon, Mr. Chairman and distinguished members of the committee. I'm going to take my time this afternoon and address the need for the amendments because, as the Attorney General said, there's a distinction in the law between simple crimes like theft or assault and when those crimes are perpetrated on a vulnerable victim. Maryland law recognizes that distinction. But what I think we're seeing in 8801 today is that it's not focused on the relationship that exists between the vulnerable adult and their care provider. It's focused on how the crime is committed. Did it involve trickery or deceit? What we're trying to do with this bill as amended is recognize that it's not about how you stole money from a vulnerable adult. It's the violation of the trust and the exploitation of your trusted position that really makes it a crime. The forbidden activity isn't being sneaky. The forbidden activity is violating a position of trust. And as the Attorney General said, and I will reiterate, in the context of a vulnerable adult, that relationship is not a choice. If you are someone who requires constant care and are in a skilled nursing facility, if you're in an assisted living facility, if you are at home, bedridden, being taken care of by your family, those are not choices, those are necessities. And so it is important, I think, that Maryland law recognize and protect that relationship. As written, though, this bill creates a new theft charge. But in the context, for instance, that the Attorney General referenced with his mother, we could already charge theft. What we want to do is get at the violation of the trust. We want to be able to charge both theft and financial crimes against a vulnerable adult so that we are addressing in court and punishing not just that it's wrong to steal, but that it is also wrong to violate a position of trust that you've been honored to accept. So I would urge a positive report on Senate Bill 466.
Thank you, Mr. Chair. Thank you, Mr. Attorney General. Good to see you. I'm looking at your testimony that has the amendment. And I'm I'm a little concerned that it might be broader than you intend it to be. If I'm reading correctly, it says that a person who is a caregiver to or a family member or household member of an individual may not knowingly and willfully obtain a property of the individual with the intent to deprive the individual of the property. There's nothing in there, I mean, that just seems very broad to me, that, you know, my mother is over 68. I can't obtain her property if she gives it to me. I mean, that seems to me that it would fall under this language, and I know that's not your intent.
And Mr. Shirley, who's in court most every day on this, I think would support what I'm about to say. In that scenario that you offered, you haven't deprived your mother of her property. She has given you the property.
Okay, how do we define deprive?
Is that recognized in law, or is that in
correct.
statute? That's recognized in law.
It is? Okay.
Yes. Exactly.
Yeah, sure. Do you want,
Yeah.
at trial, we would have to prove that you had the intent to deprive, that is to remove that property from her without her consent.
Okay, so it's defined as without her consent.
Yes.
Okay, great. That answers my question. Thank you.
No, thank you.
All right, further questions from the committee? We added some of the same concerns as well, like for just in deprive and what the intent, how you know, kind of where the demarcation would be. So we'll wordsmith this, but we'll continue on before we vote on it, though. But we'll be in touch, though.
And so, Mr. Chairman and members of the committee, I think you're right. I mean, there are so many, and you've seen this before in this committee, there are so many laws in statute that we always wonder, well, what does that mean? We're going to work with the committee to demonstrate that either it's in statute already a definition, or the courts have taken it up and have defined it in case law. Because a lot of the material that you work with every day in statute does not have definitions, but we can turn to case law to say, this is how the courts interpret to deprive, or this is how the courts interpret, you know, like, for example, in the criminal law court, where it says you have the intent to do something. Well, what is intent? How do you define that? And then the courts have shed some light, provided guidance and standards for doing that. So we'll work with the committee on that, Mr. Chairman.
Excellent. Further questions from the committee? All right, seeing none, thank you both very much. Thank you.
Thank you.
With that, that'll conclude the hearing for Senate Bill 466. We'll now move on to Senate Bill 432. Actually, you know what? My apologies. I think I missed the some of the witnesses signed up for 466. So my apologies on that. Let us go to, is Tammy, there you go. Robert Doyle.
We won't take much time. We haven't seen the amendments, Mr. Chair. Good afternoon.
Good afternoon.
Members of the,
I'm going to call up a couple other, so
okay.
Mr. Doyle, you can come on up. And then Zach Shirley's here. Is Bob Enton here? Coming up. And then Evan Richards. One more spot for you.
I don't think Mr. Richards is here.
Okay, excellent.
okay.
Please.
Good afternoon, Mr. Chair and members of the Senate Judicial Proceedings Committee. My name is Tammy Bresnahan. I serve as the Senior Director of Advocacy for ARP Maryland, and we are supporting Senate Bill 466. Like I said, we haven't seen the amendments, but we do like the intent. We think it gives the Attorney General's Office another tool in the toolbox. A few years ago, we spent some time in Montgomery County State's Attorney's Office, and caregivers, somehow family, non-family, get into a position where they are taking care of an individual, then they get their credit card, their checking account. In one case, a caregiver charged her daughter's wedding at the Trump Tower or the Trump Hotel in Washington, D.C. on the person that she was providing care for. It is a major problem, and people lose hundreds of thousands of dollars. And just talking to the Montgomery County State's Attorney's Office a few years ago, I mean, it was already over $1 million. So we feel like any tools that you can give the Attorney General's Office office and other law enforcement to curb this activity. We support it immensely. Thank you.
Good afternoon, Mr. Chairman, Mr. Vice Chair, and members, including my Senator Henson. Welcome. Good to see you here. Thank you. I'm Bob Doyle. I'm with the State Legislative Committee Chair of National Active and Retired Federal Employees. I have about 317,000 represented in Maryland, including many, many annuitants who are seniors and some vulnerable citizens as well. I read this bill, and I also wondered, familiar with the Maryland theft laws, and I saw the bill, the older bill that is not the bill in front of you today, but I said this is terrific, some of these new elements, and from what I heard from the general and his assistant, this is a terrific bill again. The violation of trust aspect, I think, is a truly good way to go at this. Just quickly, I'll tell you that I wanted to look at some data on this, and I was astounded. I found some data from 23 to 24, the Financial Crimes Enforcement Network from Department of Treasury, called Elder Theft. This is 1 year, not Maryland, but nationally, over 31,000 elder theft reports of almost $100,000 per incident. That's an amazing amount of money to lose. And everyone's described how your kids and your caregivers are the issue here. And this report from the Treasury Department, FinCEN, older adult children were the #1 thieves. Unbelievable to me, but there you have it. So thank you. We have a report with some more data, which you guys can look at, I'm sure. But I want to say, as a powerful weapon against elder theft, we applaud the introduction of this bill, and we thank the Attorney General for requesting the bill. Thank you, sir.
Thank you, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Bankers Association. We had signed up favorable with amendments. We hadn't seen the revised bill, and we had some questions about the bill as it was introduced. But with the revised provisions, we're fully supportive of the bill, and I want to publicly thank the Attorney General and his staff, Ms. Clark, for reaching out and discussing it with me this morning when I raised the issue, and we're very glad to support the bill. This is a serious issue, particularly for my clients. And anything we can do to curtail that and disincentivize people for defrauding our seniors and vulnerable citizens, we're in favor of. Thank you.
So I've just had a chance to take a look at the amendment. I think the bill sounds terrific. I do have one question. That is, let me give you a hypothetical. The husband and wife and their kids asked the husband's mother to come live with them because she's elderly and they want to help take care of her. And she says, well, I'll come, but I want to make sure I pay my fair share. So she says, I think you should take $10,000 out of my bank account each month in order to help pay the mortgage. And this is a woman who's in a position to do that, and so the family does it. As I read the language of the bill, it looks as if the family member who takes the $10,000 out of the bank account each month would fall afoul of the bill, because there's it says with intent to deprive the individual of the individual's property, but taking the $10,000 would indeed deprive of the individual's property. So I think we could wordsmith this to take care of that situation. I think that kind of situation would fall within the ambit of what the bill's trying to do. So I think it's a great bill. With a little wordsmithing, I think we can make it perfect. Thank you.
All right, further questions from the committee? All right, seeing none, thank you all very much. All right, so with that will end the hearing for Senate Bill 466. We'll now move on to Senate Bill 432. And I know we have a panel from the administration, Mr. Hicks, Joe Jones, Aaron Haney, Harold Coleman, and Megan Dermott. And then we'll bring up the second panel.
All right, well, good afternoon, Chairman Smith, Vice Chair Wallstreicher, members of the Judicial Proceedings Committee. For the record, my name is Miles Hicks. I serve as Deputy Legislative Officer for Governor Moore, and I'm here today in favor of Senate Bill 432, the Expungement Reform Act of 2025. This legislation builds on the governor's executive clemency order from last year that pardoned 175,000 Maryland convictions related to possession of cannabis. There are four major parts of this legislation. The first, you might remember from Senator Carter's bill last year, also now Judge Carter, excuse me, and some work that Vice Chair Wallstreicher did as well this year that would reverse the Abhishek decision by the Appellate Court of Maryland. In 2022, the court ruled that people whose probation was unsatisfactorily closed after a violation cannot receive an expungement. This legislation would allow an individual who completes their probation or parole to be eligible for expungement. The second part of this bill would expand the list of expungable charges to include driving without a license, counterfeiting prescription, using a stolen credit card, obtaining property or services by a bad check, resisting arrest, and making a false statement to an officer. The third provision would expand the list of depositions that are removed from public view to include set charges, and the final part removes all convictions included within the cannabis pardon that I previously mentioned from public view on judiciary case search. Over the interim, we've continued to start chiseling away at some of these issues that hinder justice-involved individuals every day. I already mentioned the mass clemency order, but I also want to highlight that we canceled the debt for outstanding mandatory parole, administrative release supervision fees, and drug testing fees for individuals who are currently under the supervision of DPSES. We continue our efforts today here with some of the advocates, the experts, the people you see in this room, who also share the governor's interest in ensuring that every Marylander has better access to work, wages, and wealth. They want to make sure that we grow our economy, and we want to make sure that we are building a better state that is more equitable and just. To close, the Moore Miller administration looks forward to continuing to leverage our executive tools that we have and working in partnership with this body and this committee to make sure that we are alleviating burdens and getting people back on track. Again, I urge a favorable report.
Thank you. Chair, Vice Chair, members of the committee, thank you for the opportunity today. I'm Erin Haney, Chief Policy Officer at Reform Alliance, a national organization dedicated to improving probation and parole systems to boost public safety and expand economic opportunity. Today, I ask you to support Senate Bill 432. Advancing this legislation brings Maryland in line with national trends. Reform has worked with coalitions to pass 18 bipartisan supervision bills across 11 states, deep red and true blue alike, all embracing the evidence-based trend away from punitive consequences for technical violations and in favor of utilizing incentives like expungement to encourage compliance and increase public safety. More than 30 states limit the consequences of technical violations, like restricting incarceration. Over 18 states use incentive systems, and several of Maryland's neighbors embrace automatic expungement without eligibility restrictions based on violations. A criminal record can devastate an individual's ability to secure a job, housing, education, and essential services, elements vital both for rebuilding lives and for maintaining public safety. Expungement is a proven tool in this regard. National data shows that as little as 6% of those granted expungement are rearrested, compared to general recidivism rates nearing 50%. More expungement means more opportunity, fewer crimes, which means fewer victims, and more people moving forward with their lives. SB 432 ensures that if someone completes their sentence and remains law-abiding, they deserve a fresh start. Would we prevent someone who missed one meeting from getting that fresh start? I certainly hope not, and I urge the committee to support the bill.
Good afternoon, Mr. Chair, Vice Chair, and members of the committee. My name is Joe Jones, founder and CEO of the Center for Urban Families based in Baltimore. We're an organization that provides family strengthening and workforce supports to Marylanders. You have my written testimony, but what I'd like to share with you to complement what has already been said and what has been submitted is just imagine that you and I are on an economic playing field, and we get a chance with our networks to play on that field, to prosper, and to take care of our families. But on the sidelines are a group of Marylanders who have the competency to play the game. They want to play the game, but they can't get in because they still have vestiges from their past, criminal involvement, and they've satisfied that debt to the state. What this does is give us, the 432 gives us an opportunity to allow those people to participate in the American game of work, wages, and wealth, to be able to contribute to their families and contribute to the tax base of Maryland. Imagine how it must feel when you see people on that playing field and you know that you can get on there and you can play, but you're restricted from playing or limited because of your criminal past. The expungement bill 432 gives us an opportunity to make this fair and equitable for all the folks in Maryland, and I would urge a favorable report.
Good afternoon. My name is Megan McDermott, and I'm an advocacy director at Maryland Legal Aid, where I represent some of the almost 2,000 clients we see each year for expungement. Since the 2022 Abhishek decision, many of those clients cannot receive an expungement because they violated probation. Probation violations are very common. Data from parole and probation shows that 43% of those under general supervision in 2022 did not successfully complete their supervision terms. In addition to including 7 new charges on the expungible list and shielding sets and pardoned cannabis offenses, Senate Bill 432 provides a simple technical fix that clarifies once and for all that probation violations are not a complete bar to expungement in Maryland. There seems to be a perception among critics that allowing probation violations to be expunged means a person gets away with something or that they aren't really being punished. This is counterintuitive. Expungement is only available post-sentence. In other words, it's a remedy only after a person has been punished. Expungement is not meant to be used as a tool to make determinations about a person's behavior when their case was active. Those determinations already happened during the life of the case. If we do use expungement that way, if we do allow the Abhishek decision to stand, we are in effect recriminalizing people. We're saying that in Maryland, we want expungement to serve as a punitive tool instead of a redemptive one. I also want to be clear that not everyone who applies for an expungement receives it, and this bill doesn't change that. It does not in any way further limit prosecutorial or judicial discretion. In fact, the bill clarifies that restitution payments and probation success may be considered in expungement determinations. This is an important bill that will open economic opportunities for many Marylanders. Thank you.
Good afternoon, Mr. Chair and committee members. My name is Harold Coleman, and I support the governor's bill, SB 432. I reside in District 10, and for 16 years I've worked at the Chesapeake Bay Bridge for the Maryland Transportation Authority as a technician 4. I often come to Annapolis to testify on criminal expungement bills to help people in situations like mine. In 2023, I supported the REDEEM Act, which cut the expungement waiting periods in half and finally made my last charge eligible for expungement. I want to thank Senator Wall-Stryker for sponsoring that bill. However, thanks to Abhishek ruling, I am barred from expungement due to probation violations in 1988, and 1997, nearly 30 years ago. I want to thank the governor and the committee members for constantly discussing this issue. I look forward to working with all of you to resolve this, and I urge a favorable report.
Hold on, we have a question from the committee, Senator Wallstreicher.
Thank you, Mr. Chairman. This question is for Mr. Hicks. And Mr. Hicks, while you're getting up, just thank you to your boss, the governor, for bringing this bill. It's an important bill. Two quick things. You listed the expansion of the expungement eligible offenses. And I was wondering, and I don't want to put you on the spot, but if you have it, could you crosswalk us through the bill? Because the bill is written not with the names of the offenses, but the sections of the offenses.
Yes, I can.
Can we walk through? So it looks to me like we start on line 8 of page 4, if that's correct. Can we, tell me if I'm getting that wrong, but can we
Correct,
walk
yeah, so you're right. They start on line 8 of page 4. And I'm going to try to go in order. 106 is, and you'll see these all bolded. 106 is issuing a bad check. 8-204 is credit card theft. 8-610 is counterfeit prescription. 9-408 is resisting arrest. 9-501 is false statement to an officer. 9-502 is false statement. I can't read my own handwriting. I'm sorry. False statement to of concealing identity, which also would be lumped in with what I lumped in with false statement to an officer. And then if you go to page 5, line 5, that is where you see driving without a license.
Thank you for that, Mr. Hicks. That's super helpful. I really appreciate it. Second thing is more of an apology than a question. I think it's important that all of us acknowledge when we were wrong. This bill was in front of us in a different form at the end of last year, and we sat down. It was during the craziness of sine die, but as the bill was in front of us, I fundamentally misunderstood some of the drafting elements of the Abishett fix from last year. And I wanted to apologize for that, because had I understood then what I understood now, we could have moved it last year, and everyone who is impacted this could have an additional year to begin the expungement of their records. But I also want to say thank you, because we sat down, I think in June and then again last month, where you and your staff, and thank you to Jennifer as well and all the advocates here, kind of walked me through and explained why some drafting choices were what they were. And I really appreciate that. And any concerns that I had that were misplaced last year have certainly been resolved. So thank you to you and your staff.
Great, I appreciate the comments, I really do.
Thank you very much, Mr. Chairman. First of all, sir, thank you for coming down and sharing your experience. And I, on behalf of myself, can't do it for anybody else, I'm sure many agree with me, I absolutely apologize that for something like that, you would have to go all of these years with a record. And so thank you for sharing that, and I'm sorry that that happened. I hope we can correct it with this bill. And thank you, my friend, for coming. You mean for existing arrest, for something like making false statements, that actually follows you? Is that what you're saying?
So yeah, so some of these charges you'll see date back to, especially
Exactly.
Coleman's days. So yeah, so these follow you until you get them expunged. They're on your record.
I think that's just very cruel. I think it's wrong. And again, I hope we can make these corrections. I wrote the first expungement bill that was then amended into the Second Chance Act, but was always, if nothing else I've done down here, it's like the number one thing that I'm thankful that I was able to do in terms of expungement. I am happy that we continue to add on because I understand it to be the correctional system, not punitive. And I think that everyone, I mean, there's some people, unfortunately, they just got to stay in jail for the rest of their life. That's just it. but I think there are a large number of people who deserve that second chance, never will get it. But thank you, and I thank those for putting this bill in.
Thank you.
Thank you, Mr. Chair.
All right, further questions from the committee? All right, seeing none, thank you all very much.
Thank you.
Now bring up the second panel, which is Melissa Rothstein, Heather Warnken, Chris Sweeney, and Chris Dews. If you could, yeah, thanks, man. There you go.
Okay. Should I go? So good afternoon, Chairman Smith, Vice Chair Waldstreicher, and members of the committee. My name is Melissa Rothstein. I am the Chief of External Affairs at the Maryland Office of the Public Defender, and I urge you to issue a favorable report on Senate Bill 432. At the Public Defender's Office, our agency's work is largely at the front end of the criminal justice process, focused on the allegations underlying the charge and the punishment imposed. Expungement law is quite different. While the prosecution and sentencing look backwards at the offense, expungement looks forward, recognizing that after someone has served their time and remained crime-free for a set number of years, removing the barriers that come from a criminal record are in the best interest of both the person and society overall. It is good for public safety to allow someone to secure housing. It is good for public safety for people to be able to obtain employment, and it is good for public safety to let people pursue education, professional licensing, and financial assistance so that they can be contributing members of their community. These are what expungement is for. Ironically, an individual who is incarcerated on a misdemeanor conviction and incurs a disciplinary infraction in prison or jail is able to seek expungement once the waiting period after their incarceration and any subsequent monitoring ends. However, under the appellate court's decision in Abhishek, if that same person was released on probation and had even the most technical violation, they are barred from ever having the case removed from their record. I've worked with hundreds of people seeking expungement, and in my experience, most were justice involved due to substance abuse. As any treatment professional or person in recovery can tell you, relapses are part of the recovery process. Life stresses result in the return to coping mechanisms that may not be safe or healthy until the body and the mind learn to adapt to other supports and habits. The learning comes from the missteps. We as a society want people in recovery to have their basic living needs met, to promote a sober and stable lifestyle. The bar to expungement established by the Abhishek decision works against those goals. SB 432 is a modest measure that realigns the law to its legislative intent and adds misdemeanors that warrant similar relief. For these reasons, I urge the committee to issue a favorable report.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, members of the committee. I really appreciate the opportunity to speak with you this afternoon. My name is Chris Sweeney with Maryland Volunteer Lawyer Service. I'm the staff attorney in charge of our workforce development project there. I'm also going to talk about the Abhishek decision primarily. I know a lot has been said on it this afternoon already. I think a few key points just warrant some emphasis. Our expungement laws right now don't require anyone to be perfect. The Justice Reinvestment Act, the REDEEM Act, these pieces of legislation are crucial to removing barriers to employment, providing second chances, specifically for people who have, in fact, committed crimes. Those laws contemplate the possibility that someone could commit multiple offenses and still eventually earn the opportunity for expungement if they comply with all the requirements. This legislature determined that 5 to 10 year waiting periods are appropriate for certain offenses, and the door does not permanently close on someone just because they reoffend. On the contrary, this bill at issue today, without passage of this correction, someone who violates probation, even if it's not for the commission of a new crime, they're permanently barred from ever getting their foot in the door to even ask for the expungement. It doesn't matter how minor the violation is, how minor the original offense was, or how long they have waited to show that rehabilitation. They'll have a permanent criminal record for offenses that this governing body has already decided are otherwise should be eligible for expungement. So this bill doesn't let anyone off the hook It does not reduce the consequences for criminal behavior or probation violations. It simply brings in line probationers and people who are serving incarceration or facing other consequences so that the expungement statute treats everyone equally. Everyone still has to comply with the existing requirements. Everyone still has to demonstrate rehabilitation through going the prescribed number of years. So let's just close this gap. It's an injustice. And with that, thank you very much for your time. I urge a favorable report.
Good afternoon, members of the committee. My name is Christopher Dews. I'm with Cornerstone Government Affairs, representing Out for Justice. And I just want to, most of the talking points have already been said, so I won't repeat that. I do just want to thank the members of the committee. I know we've had a lot of conversations with leadership, with committee counsel on how to, properly get this this bill right. This is a kind of a part two to the cannabis charges, pardoning, and the REDEEM Act. And we see this as a very simple cleanup to what was already done before. And as was mentioned before, we thank you, Senator Wallstreicher, for sponsoring that piece of legislation. Just want to quickly highlight again that this only applies. We're not necessarily greatly altering the expungement list, so this is only going to apply to charges that are already eligible for expungement. Doesn't touch unit of charges, doesn't touch subsequent convictions, and most importantly, does not stop the state's attorney's office from filing an objection if they so see fit. It also addresses restitution, the person's success at probation, so that's still a factor in when if a court hearing is required, and doesn't alter the waiting period. So I just want to be clear, because this can be confusing for some people. A probation violation is very, very different than when the expungement actually occurs. So an expungement will occur, we're talking anywhere from 5, after the person's completed their sentence, we're talking 5, 10, and in some cases 15 years later. We're simply saying that the violation should not be a permanent bar. And I just want to thank, one, the members of Out for Justice who are here today, the Center for Urban Families, as well as Harold Coleman and Mr. Battle, who are also here today just supporting this piece of legislation. And I lastly want to thank the governor's office for taking this issue on and working very tirelessly with our advocates, with the members of the committee to get this right. So with that, happy to answer any questions, and we urge a favorable report. Thank you.
Good afternoon, members of the committee. Heather Warnken, Executive Director at the Center for Criminal Justice Reform at the University of Baltimore School of Law. You've already heard from some of the most knowledgeable experts in the state on why this bill is so important and how it will work. But I want to underscore one last time, as we did the day of the mass pardon, on both the gravity of the Abhishek issue and the incredible opportunity in front of this committee here today to fix it, at next to no upfront cost and huge benefit to the state. These are problem-solving tools, as you know, that are at an enormous premium right now. So again, the fact that any probation violation, no matter how small, no matter how old, from a missed appointment to even decades-old possession of small amounts of now legal cannabis, categorically bars a person from ever accessing expungement. This is just one of those realities about Maryland that when they hear it, it really makes people's jaw drop. And I'm talking about criminal justice experts from across the country and Maryland residents alike. So we continue to say out of one side of our mouth as a state that we believe in the importance of second chances, both for our friends and neighbors who deserve and work so hard for them, and also for the economic viability of the state. Yet by allowing the Abhishek interpretation to stand, we implicitly and explicitly tell anyone who has ever stumbled that we do not. But the opportunity before you is that we can fix it. So SB 432 makes the legislative intent of the REDEEM Act, which was to improve, not limit, access to expungement, real again, giving Marylanders with eligible convictions the opportunity to earn and seek that relief. We all stumble. This bill opens pathways to opportunity and promotes the human dignity and meaningful societal participation that help any of us succeed. We urge a favorable report.
All right, questions from the committee. Senator Muse.
Thank you very much, Mr. Chairman. And I don't really talk a whole lot on this committee. I don't ask a bunch of questions and that sort of thing. So if you would indulge me to just say this and then and ask a question. In some rooms, the elephant in some rooms is this. When things like this, and you go back to the war, war on crime and that sort of thing, it was all geared toward black people. Here's my experience with that. And I say experience because being black in America is not so much the color of your skin as it is the experience that I know that I, as a black man, have faced many times. We keep talking about the fact that in the United States, we incarcerate more people than anywhere else in the world, as far as the stats that I've looked at. And what the governor said this morning was right. When we talk about black men and black boys, that's who are filling our jails for something that we acknowledge is a problem, but we don't want to say why it's the problem. And when it comes to making changes for that, we don't want to do it. And so looking at what you have done, just this, probation, you mess up. I mean, I've stolen food to eat when I lived in the streets. I've stolen water, I've stolen blankets, I stole whatever I could get so I could live and make it, okay? This bill, many are saying is a, get off free card 30 years ago. Get off free card. How do you respond to those who would say this bill for traffic stops and all else is not necessary because it has no impact on today?
I would very bluntly say, as the statistics show, having a criminal record is a massive barrier to housing, education, employment, financial assistance, business loans. Basically, some would argue that it's just a bar from being a proper American citizen, right? You can't participate accurately in the economy, as Mr. Joe Jones said before me. I mean, as an African-American man myself, from family members to friends to colleagues to just people in my own family, we see on a day-to-day basis how you put in 85 job applications, but because of a record from 30-something years ago, you just can't move forward. More importantly, we see how these types of effects frustrate people, turn them into individuals that they may not necessarily be, but more importantly, the intergenerational effects it has on children, that they watching mom or dad not be able to properly participate and take care of themselves or their family, it has incredibly vicious and detrimental effects. So I simply just say that to say that I echo your sentiments. I think that the governor's initiatives on work, wages, and wealth, this is like all in line with that, from this, the Enough Act, and others, to kind of move in a direction that I think is going to address and fix those issues. And the last thing I will say about expungement is, again, this is not about sentencing. This is about after the person has completed their sentence and waited the required waiting period, allowing that person to move forward. Last thing I'll say is we've got experiences where individuals have violations for trespassing because they were homeless and needed somewhere to sleep, so they were sleeping in a parking garage. And the fact that that is going to stop you from being able to secure employment so that way you can work to make money so you can buy your own house and have a place to stay is somewhat illogical and irrational. And unfortunately, our laws sometimes do lead in a perspective that will harm individuals that look like myself.
And that's the last thing that you said. Had they caught me, I wouldn't be sitting here. That's number one. Not ashamed of that. And I hope that everything that I say, committee, friends, and all else, I say it in the spirit of love and justice, nothing else. I say it because Michelle Alexander wrote a book that's entitled The New Jim Crow. And we've got to get away from that every time we come up with an answer to one thing, we come back and legislate something that will undo what we've done that should help the poor, those who are the least of us, and that's not done. So I commend you all for fighting for this bill for my own reasons and out of the rights. I hope that you receive it in the spirit. If I said it wrongly, charge it to my heart and not my head, but I mean what I said.
We thank you for the question.
If I can add sort of briefly to that, I think Mr. Juice has spoken. Oh, I'm sorry. If I can just sort of briefly add, I mean, and I think in addition to all the sort of the impact of it that Mr. Juice had talked about, with respect to some of the racial justice issues that you're discussing, you know, there is data that shows there are racial disparities at every point in the criminal justice system.
Absolutely.
That includes who is getting arrested, who's getting these convictions in the first place, and also who's getting these violations. And so allowing for expungement in these areas is also a way to mitigate some of the harms of that racial justice as well. And so, you know, and so that they can have these opportunities.
Thank you. Thank you. Thank you for allowing me to.
Thank you. Mr. Dews?
Yes, sir.
Could you, just for my edification, last page 7, lines 5 through 10, just again explain to me what's going on here?
Okay, you said page 7, lines
5 through 10. I mean, I guess the statute actually starts on page 6. I mean, so it's 10-401.
Yes, this is adding to I want to say, a statute that was created in response to, I want to say it was a piece of legislation that passed in 2020 that would remove certain charges or certain things from case search. So this is just removing from public view. And for what's being added from line 5 to line 6 is a stat docket that was at least 3 years old. So if it's 3 years old, it's just being removed from case search. Doesn't mean it still does not exist. It just means it's being removed from case search.
That right there answered my question. That's what I was trying to figure out, because we're talking expungements, but this is just
for that specific section.
It's just
different.
shielding it from people.
Yes.
On the system.
Yes.
But it's still there, so it's still in the record. So if you went down to the court, you could still.
For this specific section.
Right.
Yes.
Thank you. That's what I was just confirming.
Thank you very much, Senator. Actually, it's fun. It's a very good question. So first, I want to say compliments to Mr. Hicks, because he, you know, you were prepared to kind of outline all the sections, and you had the bill before you, and that's a very good thing, because that's not always the case. So, but that brings us to the second point. I know that Mr. Dews wanted, just for the record, you said that this bill doesn't expand some of the offenses that are eligible for expungement. I think that's incorrect, as I've identified at least six new offenses. Yeah.
Yes.
So just for the record. Yeah.
As in, yes. Yeah. Yes. It adds 6 additional charges. I was just saying it's not a total overall, because I've heard conversations that have happened about that. 6, because, and that's why I thought it was good with the crosswalk with Mr. Hicks to understand, you know, what we're doing what
here.
the charges were.
And then lastly, so for Senator Sidnor's point, are the offenses that are on that 3-year stat docket, are they eligible for expungement, or are they just things that have been stated that we don't know what they are?
I would like Ms. Rothstein to answer that question.
Well, that's a question in terms of the bill itself. Right.
Well, that's what I'm saying, because they're kind of, it's a weird purgatory.
Yeah.
Right. I mean,
so
stat is a weird purgatory.
Yeah.
And I mean, in terms of the bill, it's for all stats, right? So it would be. I mean, a stat is ultimately eligible for expungement anyway. So we're not. This is actually a part where it is accurate to say this isn't changing the scope of who would be eligible. It's just saying while it's in that initial kind of purgatory period, it's just not going to be on case search. If something happens later where it gets removed from the stat docket and then there's like a new charge or something happens there, it hasn't been expunged yet, and so that would still be available. And then once it's eligible, you know, for expungement, that this bill doesn't change that.
No, I get that. I just want to make sure we're all clear, like, as to what the bill does. And then compliments to the team that put this together. I know it's been a couple of years in the making. You know, Ms. Warnken, I think you kind of elucidated exactly why this is necessary, especially for technical violations, small things that are setting people back for decades. I think it's going to unlock a lot of opportunity for a lot of people. So compliments to Senator Wallstreicher and to the governor and Mr. Hicks and to all of you all here as well. So thank you all. All right. With that, I think that will actually. Is Harold Coleman already spoke? Who else is here for that? 432. All right. We have the next. We'll go through Mr. Wiggins, Adrian Roca, And then we will switch over to favorable with amendments after that.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce in support of the bill. As we talk about expungement and its impact on employment, just wanted to come in and talk about the importance of employment here in Maryland. Unfortunately, last year we did rank 49th in job growth among the 50 states. And so we believe that this bill, and we'll be in support of Senator McKay's bill as well, will help create career pathways for people who may be currently blocked. And so for that reason, Mr. Chair, we are supportive. Thank you.
Excellent. Thank you very much. Questions for Mr. Wiggins? All right, seeing none, thanks. All right, now we'll switch over to favorable with amendments. Do we have John Cox and Stephen McDonald?
All right. Thank you, Chair and a member of the committee. My name is Stephen McDonald, and I'm a member of Local 5 Plumbers and Gas Fitters and a resident of District 28, Charles County. I strongly support Governor Moore's Expungement Reform Act of 2025, with this will assist me in moving forward with my life. I only request a favorable amendment to allow Criminal Law 5701D to be added to expungement list. When I was 18 in high school, I had a spine injury with the doctors overprescribed me with Oxycontin, which was the encouraged drug at the time. There wasn't much discussion about addiction, which became the nature of my only charge. I had a violation of probation because I was working 2 jobs and I was released and didn't, when I was released and didn't make it to my PO meeting on time, so I was violated. Passing the Governor's Expungement Reform Act of 2025 would help me tremendously in allowing the violation to be expungible. Under the only amendment I would make is to add Criminal Law 5701D, possession of a counterfeited prescription, to expungement list. The Governor's bill is already adding Criminal Law 8610, counterfeiting prescriptions, to the expungement list, and Criminal Law 5601, which is a misdemeanor. Counterfeiting or altering a prescription is already expungible. 5701D, 8610, and 5610 are essentially the same charge in 3 different statutes. If this can be rectified by adding 5701D to the expungement list, it would clarify the Governor's intent to help individuals like me who survived the prescription opioid epidemic. Under Maryland sentencing guidelines, 5701D crimes are nonviolent, low-level misdemeanors with the lowest serious category of 7. I urge a favorable report.
Mr. Chair, members of the committee, I'm John Cox. I'm Deputy State's Attorney for Baltimore County and also speaking on behalf of the Maryland State's Attorneys Association. We urge a favorable report with an amendment. I came down here last year and actually testified against the legislation that was addressing the Abishak opinion in its original form. And when I testified, I said that my concern was that it was ignoring the issue of restitution for victims. That the expungement was going to happen despite the fact that the money is still owed to the victim of an offense, and then we would be wiping out all record of that for the victim to be unable to do anything about it past that point. I believe, if my memory serves, it was Delegate Bartlett's bill over in the House side. They then amended the bill to include what is in it now with regard to 10-110, and that is a portion that addresses the issue of monetary restitution ordered by the court, or the individual doesn't have the ability to pay it. And that was fine. The bill now has that. We support that. The problem is it's not in 10-105. So that requirement or the issue of restitution is not in 10-105, which addresses PBJs. It's only in 10-110. So what we'd ask is that it be included into 10-105 also. My recommendation would be that if you take the language that's currently in 10-1, or the proposed language at lines 23 through 25 at page 6, if you literally just take that language and add it to the end of the proposed definition of completion of the sentence, which is at line 1 through 3 on page 2, as the definitions, if you just add that language to the end of that in completion of sentence, then you're going to get to the point where it's going to be applicable to both PBJs in 10-105 and the guilty findings in 10-110. Thank you.
Just to be clear, Mr. Cox, what you're asking is just to take that and make it a part of the definition of completion of sentence.
Yes, sir.
Okay, thank you.
All right, further questions from the committee? Excellent. That's like a miracle. The state's attorney's coming in, it's support, you know? I thought your amendment was going to be to strike the entire bill, you know? This is good stuff. All right. All right, seeing no further questions, Mr. McDonald, thank you very much for your testimony. Seeing no further questions, that'll conclude the hearing for Senate Bill 432. Oh, sorry, do we have someone joining us virtually? Oh, is that Adrian Roca? Yeah, okay. Yes. Mr. Roca, welcome.
Thank you, Chair. Really appreciate your time. Members of the committee, appreciate it. My name is Adrian Rocha. I'm the policy director for the Last Prisoner Project. Last year, we had the distinct pleasure and honor of joining Governor Moore as he issued the single largest state pardon proclamation for cannabis offenses. We're here to further support additional reforms to further streamline the expungement process. A criminal record can create barriers to employment, housing, political participation, public assistance, and further consequences of other speakers have noted today. According to a study conducted by the Center for Economic Policy and Research, the United States loses about $78 to $87 billion in annual GDP because of the consequences associated with having a criminal conviction. And that doesn't even include other factors that are less quantifiable but no less impactful, like the potential disruption to educational trajectory or the loss of specialized skills or housing. The potential benefit of expungement reform in terms of sheer numbers is notable. According to the U.S. Department of Justice, an estimated 70 to 100 million Americans face nearly 45,000 separate collateral consequences that exist through federal and state law. Additional regulations may also apply at the municipal and county levels. At Last Prisoner Project, we've helped design, advised, written, and helped implement over a dozen criminal record clearance laws across the nation. And all too often, we've encountered record clearance laws whose various procedural hurdles are considered key features intentionally designed to be onerous for the petitioner under the guise of promoting public safety by limiting relief to those who have the time, resources, and ability to navigate the varying laws that determine eligibility. However, consistent research has demonstrated that record clearance does not pose a risk to public safety. In fact, record clearing laws support public safety by increasing access to jobs, housing, educational opportunities, and promoting community reintegration and stability. In fact, our own constituents who we've helped lobby to get criminal record relief have a recidivism rate of less than 2%. The Expungement Reform Act of 2025 seeks to make common sense changes to the expungement procedure by relaxing bureaucratic barriers, and we support a favorable passage. Thank you for your time.
All right, thank you very much. Questions from the committee? All right, did I miss, was it Cam? Cam Bridges, did I miss Cam Bridges? Come on up.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Cam Bridges, and I'm a public policy advocate for Job Opportunities Task Force, a nonprofit organization that helps low-wage workers gain access to higher-paying jobs. Over 1 million Marylanders are burdened with a criminal record. Criminal records can serve as both the cause and consequence of poverty. Workers and job seekers with a criminal background apply for jobs for which they are well qualified, but they are not considered due to their records. Technological advancements have made access to criminal background information easier, which creates often insurmountable barriers to obtaining employment, housing, education, and other critical resources. In an era of rising childcare costs, ballooning healthcare costs, the ever-increasing housing and rental markets, and prohibitively expensive costs of higher education, having a well-paying job is a necessity. The days where financial freedom was accessible to a significant portion of Marylanders are in jeopardy, and the percentage of Marylanders who can even hope for even short-term financial security is dwindling. Preventing large swaths of Maryland citizens from accessing gainful employment will exacerbate many issues, including homelessness and public safety. Maryland must remove barriers to employment, not build them. This legislation will allow individuals who have completed their sentence to have their records expunged so they can truly move on and become active contributors to Maryland's economy. JOTF appreciates the opportunity to testify and asks for a favorable report on Senate Bill 432. Thank you.
Thank you very much. Questions from the committee? All right, seeing none, thank you. Thanks a lot. With that, that'll end the hearing for Senate Bill 432. We'll now move on to Senator Reedy with Senate Bill 418.
Thank you, Mr. Chairman and members of the Senate Judicial Proceedings Committee. It's always good to see you. Senator Justin Reedy, for the record, from District 5 and the Senate chair of the strong and mighty two-member Carroll County Senate delegation. So with my fellow senator, Senator West here. Senate Bill 418 is a local bill, would expand the authority of Carroll County government to conduct criminal history record checks for all prospective employees. Currently, the Department of Human Resources in Carroll County only requests for prospective employee or volunteer if their position is involved in inspections, approval, denial of permit, or other granted authority, or if they work in the sheriff's, state's attorney's, circuit court, or county attorney's office. There's other employees in other categories, and they're wanting to just be able to do it for all. The desire here is not, for example, that if someone who's applying to be on the county roads department committed some minor crime 20 years ago, they're not going to get a job. But with the issues of increased liability for governments and some other things that have come up, our county commissioners and the government had asked that they just be able to do this as needed and run these background checks. So the bill currently, I believe, Allegheny, Hartford, Kent, Cecil, Caroline, Dorchester, and St. Mary's do this way. Most, I think all counties have some level of background checks, but these counties have done it for just the ability to do it for any employee. With that, Mr. Chair, I would ask for support of the bill and happy to answer any questions. I don't think I had anybody here to testify. It's just a local bill.
Pam Meister's signed up virtually.
Oh, okay. Pam's on. Okay,
she is here, so we'll hear from her, and then we'll take questions from the committee.
Ask for support of the bill and happy to answer any questions. I don't think I had anybody here to testify. It's just a local bill.
Hey, Pam, if you could, I guess your browser, if you could collapse the browser that you're streaming and then, or mute it, and then we won't get the feedback, and we'll be ready for your testimony. Welcome.
Hi, thank you. I've closed my browser.
Excellent.
Are you ready now?
Yes.
Okay, thank you. I'm Pam Meister, Legislative Liaison for Carroll County. I want to thank you for your time and thank Senator Reedy and Senator West for your support. I wanted to just echo what Senator Reedy shared and just clarify as well that we just want to align Carroll County with what other jurisdictions are already doing. This is just expanding a screening process to ensure safety and reduce any additional risk to the county, making sure that we are ensuring public confidence as well. The process has been something that they've done for, as you know, some other positions, and if something comes up, it is thorough. It's not just like a blanket, no that someone gets. If something pops up, usually there's an exploration process as well, so it's very thoughtful. But everything else that I was going to say, Senator Reedy, you so eloquently already explained, but I'm happy to answer any questions if they exist as well. Thank you.
Excellent. Thank you very much. Questions from the committee? All right, seeing none. Thank you very much, Senator.
Thank you, Mr. Chairman.
All right, with that, that'll end the hearing for Senate Bill 418. We'll now move on to Senate Bill 504, and I see Senator Quarterman is here. Welcome.
Chairman, you mind if I bring my individuals up with me?
Of course, please.
Thank you. Yep. Should I go ahead and go? Okay. All right. Thank you, Mr. Chairman. Thank you, members of the committee. For the record, Senator Paul Quarterman, District 2, representing Washington and Frederick counties, here today on behalf of the Washington County Senators. Thank you for the opportunity today to present Senate Bill 504. This bill would authorize the Hagerstown Community College police officers to exercise police powers granted to peace and police officers within Washington County. It's important to note here that nothing in this bill may be construed to, one, supersede the authority or jurisdiction of the Washington County Sheriff's Office or any other law enforcement agency, or two, limit the authority or jurisdiction jurisdiction of the Hagerstown Community Police Force authorized under provisions related to the statewide jurisdiction of officers for controlled dangerous substance offenses. There's been additional growth around the current campus. The college is currently also expanding their footprint outside of the campus within Washington County, so the authorization of these officers would complement, enhance, and become a force multiplier when it comes to public safety and assisting other law enforcement entities within Washington County. Uploaded, you will find letters of support from the Hagerstown Police Department as well as the Washington County Sheriff's Department. Additionally, this bill was passed unanimously in our delegation. As such, you will see a delegation letter as well. As such, we respectfully ask for a favorable report on Senate Bill 504. Thank you. If you have any questions, feel free to answer them. Thank you. So, Dr. Clover.
Thank you, Mr. Chairman, Mr. Vice President, Chairman, members of the committee. My name is Dr. Jim Clover. I'm president of Hagerstown Community College, and I don't think Senator Quarterman could have said it much more eloquently. The college, over its 79 years, has grown from being a little location out on the edge of town to town has come out to where we are. And within about a half mile of the college now, we have 2 elementary schools, a hospital, and this fall we're going to have a medical school. So with all that activity, we work very closely with Washington County Sheriff's Office and the city of Hagerstown. And this bill would enable us to do some reciprocity agreements with them in the event, you know, God forbid, there was some active shooter at one of the elementary schools or at the hospital. You know, our police force can get there and respond very quickly until other additional help arrives. Plus, our police force is at the Washington County Training Center, Public Safety Training Center, where they have a police academy. They're out there. It's not our property, it's the county's property, and it would be very beneficial for them to have some jurisdiction in case there's an auto accident or something out there on the highway where we may need to work traffic. So, you know, those are some things that we've considered going forward. It really is kind of a logical expansion over the 79 years that the college has been in existence. And as we grow and our community grows, we want to be able to serve our place. Also, in closing, we're the reunification center for the county at our ARC, and that also, you know, you've got law enforcement issues there as well, working with the county and city police. So, subject to questions, I brought along my police chief, Chief Eric Byers, who would definitely be the subject matter expert on this, and we would urge and ask for your passage.
Thank you, Mr. Chair. Could the police chief step up to the mic, please? I'm just curious as to what his real qualifications are here as far as, no, I'm just kidding. It's good to see you, Chief.
It's good to see you as well.
Good to see you. No, that's all I have. I know. That's for my Eagles this weekend. So, no, thank you for bringing those birds. No, it's good seeing you. Thank you all for bringing the bill. Thank you.
Thank you.
Just to be clear, and this is for the chief as well. When I look at the language on page 2, lines 1 and 2, it seems you're expanding the jurisdiction, not just beyond the current bounds, which is property that's owned, leased, and operated by and under the control of the community college, but anywhere within Washington County?
No, I think what our college attorney, the intent behind the changes to this legislation were very minor in nature. What we're trying to do, the general intent behind this is not necessarily to extend our jurisdiction to handle, say, a domestic across the street at one of the communities that surround us. What this is intending to do is just allow us that protection when asked to do so by the Washington County Sheriff's Department to assist at, say, an active assailant event at the hospital. If we were called off our campus, we would have that authority and that protection under the law to leave that campus. So we're not actually trying to expand the area that we enforce or we patrol, so to speak. But with us growing and moving into the city, into Hagerstown City, this legislative change allows us to engage in MOUs with those allied agencies. In the past, we were not allowed to engage in any type of MOU just because of the restrictive nature of House Bill 361. These small changes don't really expand our jurisdiction, just allow us the ability to be a force multiplier when needed. And when we're traveling to and from our different locations, if we were to see something, it gives us that opportunity and protection under the law to handle that situation.
But if I'm reading Section B, it seems currently you're already allowed to engage in fresh pursuit of a suspected offender, to help with traffic, and to go beyond the current bounds if ordered to do so by the governor. Otherwise, you're restricted to essentially to campus. But this says the police officer may, under this bill, exercise these powers on any other property within Washington County, right? So again, that's not an expansion of your jurisdiction?
Not necessarily. I think what it allows us to do under the Statewide Jurisdiction Act, if we are asked by another police department within that jurisdiction to come help, we would be able to come into that jurisdiction to offer assistance. So if the Washington County Sheriff's Department said, hey, we need all police to respond, we had an event there in our county at one period of time, and a lot of the local law enforcement was taxed at the actual event site. The hospital sits within a mile of our location. Meredith asked for us to come up and do patrols up there at their hospital, technically outside our jurisdiction, but we went up and offered up to help. With teasing this law out a little bit and changing that, it allows agencies to ask us and request us to come out. The restrictive nature of this law was only on the property of, and I think it kind of ignored the Maryland Criminal Code 5802, which gives us statewide jurisdiction. So I think if that answers that.
It does. Do you know why the law was drafted in that manner back when it was initially passed?
So honestly, I think in 2009, it was just the natural progression of the police department. In 1966, the college had security. It transitioned sometime in the 90s, in the mid-90s, to additional security, and then SPOs, which are special police officers. And then in 2009, House Bill 361 was drafted with the intent of creating a police department. I think there was one other community college in the state of Maryland at the time that had a sworn police department. So I think the intent back then was, we're creating something new. Let's go ahead and let's set some barriers. Let's set some guardrails. But now that we've grown and we've seen that, like, our department right now has grown and become a professional police department within the county, and in rural policing, just being that force multiplier and having that ability to go off campus to help. And we've taken on such a role in not only policing, but emergency management within the county. As Dr. Klauber has stated, we're the reunification site for most of the Washington County public schools in the event of an active assailant situation. So we actively are out in the community being one of those planners and helpers when it comes to emergency management within our community. So I think it's just a natural growth, and we felt it was best to come back to the legislative body to see if we could change that just enough to give us that authority to come off campus.
Thank you very much.
Senator, can I add one clause to what he said? Also, in the current law, the activities of the police force are limited by the Board of Trustees. And so the board would ultimately approve any agreements that we would have with the city police and Washington County Sheriff's Office for reciprocity activities. So the board has some limitation on that as well.
Thank you, Mr. Chair. I was wondering if you can help me understand, because your testimony doesn't seem to connect with the changes that I'm reading. As I hear what you're saying, you want the ability to enter into MOUs and help other departments. But as I read the language, it says you can do things outside, you can do things anywhere in Washington County if you're engaged in fresh pursuit of a suspected offender. It's necessary to facilitate the orderly flow of traffic around the community college, or ordered to do so by the governor. So it doesn't expand the things that you're able to do. For example, some of the things you mentioned. Am I reading this wrong, or can you help me out here?
No, and when our attorney sat down, I was kind of, the language changes that she made were very subtle in this language. And it does appear that we still only have those three abilities, those three things to do. What she was intending to do in the initial part of the bill, when she made those changes, was to subtly say that that is our main focus on Hagerstown Community College, not to to go outside the original intent of this House bill. And then the last paragraph is what we were looking at, is nothing in the above section is to contradict the Hagerstown Community Police Officers' statewide jurisdiction as afforded in accordance with provisions outlined in Maryland Criminal Code 5802. So our bill, this bill as it was written, if you look at how they drafted, 5802 spells out what police officers are allowed to do. So we're defined as a police department, duly sworn police department. But when you come back to our House bill, it really restricts us to only those three things: engage in fresh pursuit, necessary to orderly flow of traffic, and by the governor. I believe they could have made additional changes and listed out other duties in there. I think what they were trying to do was take away that prohibition from looking at us as a sworn police agency under that Maryland Criminal Code 5802. So if the Sheriff's Department were to say, hey, we need help across the street, or we need help at the hospital, we could act on that and leave our campus and patrol other than just on the community college.
Okay, thank you.
Yes, ma'am.
So just for the, Senator, I think you're right. I think this may actually inadvertently curtail some of the jurisdiction the way it's drafted, but we'll take another look at it, because it's the police officer may, and you're taking out not, so it's may exercise those powers on any other property within Washington County. And then because you added within Washington County, if it was silent, then it would be broader, and unless you took out, and then you have a specific enumerated number of what you can do. So we'll talk. We can fix it very easily, but we understand the intent. So yeah, we got it. Yeah. Got it.
Thank you.
All right. Further questions from the committee? Seeing none, that'll end the hearing for Senate Bill 504. Thank you all very much. Thank you. All right, we'll now move on to Senate Bill 455. Senator McKay, you ready to go?
Yes, sir.
Mr. Chair, I believe I have one witness virtually. Yes. Excellent. Okay. Excellent. Well, Mr. Chair, members of the committee, thank you for allowing me to present Senate Bill 455. Now, I know what you're wondering. What did William Shakespeare say about the responsibility of security guards? I knew that was exactly what you were thinking, Mr. Chairman. So, in Macbeth, Act 2, Scene 1, give me my sword, who's there? Baku, I probably pronounced that wrong, was startled in the night. Instinctively, he grabs his weapon, showing how security of vigilant are valued even among noblemen. But in all seriousness, Senate Bill 455 will empower security agencies to hire and manage special police officers, allowing them to align directly to the client's properties instead of being limited to positions as in an in-house security at those properties. Now, current law restricts the hiring capabilities solely to the property owners, which brings about several significant challenges. This is nothing new. Jurisdictions like the District of Columbia have this ability. It also allows security agencies that have already been licensed by the state MSP to hire and manage special police officers. By law, these licensed security agencies are required to have either 5 years of prior law enforcement experience or 5 years of experience as a licensed investigator, ensuring that they possess the necessary expertise to oversee these officers effectively. In addition, it enhances the liability protections. The accountability for actions of special police officers lie with the security agent and subsequently the property owners, establishing an additional layer of insurance that does not exist for properties employing their own special police officers. I urge a favorable report and look forward to your questions.
All right, thank you very much, Senator. We're going to hear from Evan, and then we'll open it up to the committee for questions. Mr. Abnett, you're up. Welcome.
Hello. Can you guys hear me?
We can.
All right, I appreciate it. Good afternoon. My name is Evan Abnett. I serve as the president of the Maryland Investigators and Security Association, which includes members throughout the state. It's important to understand that Maryland Special Police Officers already exist throughout the state and require extensive training. The Special Police Officers' powers are limited to the property that they are assigned to protect. In contrast, security officers have no detainment authority. Special police officers assigned to security agencies already exist in the district, as the senator mentioned. This legislation that we're discussing simply empowers licensed security agencies to hire and maintain special police officers, allowing them to be assigned directly to clients' properties instead of being limited to positions of in-house security for those properties. Currently, the law restricts this hiring capability solely to property owners, which brings about several significant challenges. Currently, only large affluent properties or businesses that have the capacity for a dedicated security manager can truly provide the oversight required for managing special police officers. This includes handling scheduling, training, compliance with MSP regulations, and enforcing policies. Licensed security agencies are required to have a person with 5 prior years law enforcement investigative background. Many smaller properties, such as apartment complexes, lack the resources or expertise necessary to manage special police officers effectively. This is an issue especially pronounced in lower income and culturally disadvantaged areas where funding is insufficient to afford off-duty police officers at rates of $100 an hour or to employ a full-time in-house security manager. This bill is crucial in addressing that gap, providing these communities access to essential security services. It also adds jobs directly to the community, income for our members, and licensing and revenue for the state. Additionally, we know that police departments are currently facing significant staffing shortages, resulting in delayed responses to nuisance issues. This bill will enable special police officers to handle these situations, such as trespassing, disorderly conduct, and individuals under the influence within our community without necessarily involving public law enforcement, allowing our dedicated police officers to focus on more serious crimes and immediate attention. In conclusion, special police officers serve an essential role in Maryland with required training and licensing, regardless of employment context. By supporting this bill, you empower security agencies to better manage these officers and deploy them to client properties where they're needed most. By doing so, it not only enhances the safety of security across Maryland, but bridges the gap in our communities, especially those in need. Thank you for your attention and consideration, and I ask for a favorable response.
Excellent. Thank you very much. Questions from the committee? All right. Oh, actually, Senator Sidnor has a question.
Sure.
And good afternoon. I'm looking on page 2, and I wanted you to help me to flesh out the distinction between what lines 5 through 8, which you all are asking to draw a distinction between what is already currently in law under number 4, which states a person. It talks. It says it mentions one of the entities that can apply for this appointment, and it's a person that exists and functions for a legal business purpose in order to protect its business property. And the language that is mentioned in this bill is a person that holds a valid license as a security guard in order to protect property owned or leased by its clients. Can you help me with the distinction?
Sure, I can. So right now, the way the law is written is as I said, a property owner is the only person that can employ a special police officer. This allows contract security agencies to manage and employ special police officers for details on their client's property. So thus, the client themselves is not required to manage these people, manage these officers specifically, because they don't have, typically they don't have the background or the
expertise
or any of the procedures for doing that and or licensing. So right now, like as I said, it specifically states that only properties themselves can hire special police officers. So let's say a property wants to hire a special police officer. They can't do that if they don't have a security manager that can provide the training, the licensing, the oversight, and so on and so forth. This simply allows security agencies, contract security agencies, to supply that service on behalf of their client.
So under the current law on lines 3 and 4, that isn't currently contemplated? That's the scenario that you mentioned with the...
That's correct, right. So like, for instance, we have a facility here. My security company has a facility here where we do work that needs additional protection. Now, as a security agent or as a property renter, I can have special police here, but I can't hire an outside agency to provide those services. Now, I mean, I wouldn't do that anyway because I'm a security company, but you know what I mean? So like, for instance, hospitals have special police officers. Some community college have special police officers, but other communities that can't afford either off-duty police officers or can't afford to hire their own full-time security manager to handle those special police officers, provide training for them, provide licensing for them, uniforms, equipment, so on and so forth, and oversight, can't do that without hiring an external agency. So that the only thing that this does is allow licensed security agencies by MSP to hire and maintain a special police staff for their clients, and their powers would be restricted specifically to their client's property.
Okay, thank you.
Absolutely.
Thank you for the question, Senator.
All right, further questions from the committee? Seeing none, thank you very much, Senator.
Thank you, sir.
For having it. With that, that'll conclude the testimony in the hearing for Senate Bill 455. We'll now move on to Senator Sidnor with Senate Bill 567.
Good afternoon, committee, Mr. Chair. So in Maryland, if a citizen wishes to take action for a crime committed against them, they have two options. First, they can file a report with the police department, or they can go to a district court commissioner. Excuse me one moment, my notes are out of order. One moment, Mr. I'm gonna get my computer and read from that. All right. Oh, sure, absolutely. So if I may start again. In Maryland, if a citizen wishes to take action for a crime committed against them, they have two options. They can file a report with the police department, or they can file an application for statement of charges with the district court commissioner. Notably, Maryland is in the minority of states that permit a civilian to institute criminal proceedings through a district court commissioner. When reports are filed with police departments, police officers will review the report, determine if an investigation is warranted, gather evidence, and identify a suspect. If probable cause is determined, they are authorized to make an arrest. It is a second method for having arrest effectuated that Senate Bill 567 seeks to address. Under current law, upon review of an application for a statement of charges, a district court commissioner may issue a summons or an arrest warrant. Arrest warrants may be issued without the involvement of a police officer or a state's attorney. To issue an arrest warrant, a district court commissioner must find that 1, there's probable cause to believe that the defendant committed the offense charged in the charging documents, and either a defendant previously has failed to respond to a summons that has personally been served or a citation, the whereabouts of a defendant are unknown, or the issuance of a warrant is necessary to subject the defendant to the jurisdiction of the court, or the defendant is in custody for another offense, or there is probable cause to believe that the defendant poses a danger to another person or to the community. Unfortunately, the current system has been weaponized by some members of the general public, wasting judicial resources and leading to arrest of individuals based entirely upon the details within the application reviewed by a district court commissioner who notably is not required to have a law degree. Last session, the Office of Public Defender on a similar bill testified that it represented a woman who was the victim of a domestic assault at the hands of her ex-husband. The week before her ex-husband's trial date, where she was to testify as to the abuse he had inflicted upon her, the ex-husband filed a false application for statement of charges against, and her name was just Jasmine, leading to her arrest. The arrest caused her to miss the trial date where she was scheduled to testify against her husband. The charges against her were later dismissed, but the damage had already been done. Senate Bill 567 addresses this very issue by an additional factor to the decision tree for when a district court commissioner may issue an arrest warrant. Senate Bill 567 narrows the individuals who may file an application for the statement of charges to a police officer or a state's attorney. The redefining of what individuals may file application for statement of charges to police officers or state's attorneys helps establish the necessary safeguards to ensure that this legal system is not weaponized by civilians against fellow civilians. We cannot have equal justice under the law without a process that includes so little vetting and due diligence over allegations that may significantly lack merit. For these reasons, I urge the committee to provide a favorable report for Senate Bill 576. Thank you.
Good afternoon, Chairman and members of the committee. My name is Brian Levy. I'm a supervising attorney at the Office of the Public Defender. I am here on behalf of the Office of the Public Defender and ask you to issue a favorable report on Senate Bill 0567. As Senator Sidner explained, under the current law, anybody can walk down to the commissioner's office and swear out charges against another person. District court commissioners are neither tasked nor equipped to investigate the allegations that are put before them, and as such, typically, they're going to take those accusations at face value. When allegations of a dangerous act, such as an assault, are alleged, that means that a commissioner typically is going to then issue a warrant for the accused arrests. This occurs despite the fact that police may never have been called, no investigation may have been done whatsoever, and there may be no evidence at all corroborating the allegations. This current system allows for the abuse of the commissional charging system and the issuing of arrest warrants in cases that are not viable and oftentimes that are based on false allegations. In my experience as the supervising attorney at the East Side District Court in Baltimore City, arguably the busiest district court in the state of Maryland, we see abuse of this quite frequently. And it is, as Senator Sidnor's example illustrates, often by perpetrators of domestic violence who have more agency many times than their victims, using the criminal legal system against the victims of their crimes. This bill would create a more balanced and sensible system by limiting the commissioners to issuing arrest warrants only in cases where an application is filed by the state's attorney's office or the police. It would significantly reduce the number of instances in which arrest warrants are issued in meritless cases. victims can and should call the police, who can investigate the allegations made against that are being made, and where the police do not, for whatever reason, choose to file charges, individuals can still go to the commissioner's office. My time is up, but I would ask the committee to issue a favorable report. Thank you.
Good afternoon, Chair Smith and members of the committee. For the record, my name is Yanetta Emanuel, Public Policy Director with the ACLU of Maryland, and we're here in support of Senate Bill 567. You've already heard what the bill does, so I won't go into that, but just want to highlight that this process is utilized by many people and often abused, as you'll hear from more of the witnesses today. And this is because a thorough investigation is not a standard process for consideration of citizen-issued applications of statement of charges. A 2014 report by the Commission to Reform Maryland's pretrial system showed that in 2012, citizen complaints comprised 42.8% of total charging documents issued by district court commissioners. In Prince George's County, citizen complaints comprised 60% of charging documents. And while these applications do warn against these false statements and statements are punishable by imprisonment up to 6 months, there are very few safeguards in place to ensure that these applications are properly vetted and people are rarely held accountable for making these false statements. We often see this in abusive relationships where abusers weaponize and misuse the court system to maintain power and control over their former and current partners. Additionally, we've seen these cases in adversarial child custody battles where one parent will make a false allegation of abuse against the other parent as a way of gaining leverage in court proceedings. While some people may eventually be able to clear their name and get charges dropped, this comes after months and sometimes years of incarceration, and after not only the individual but also their families have been completely traumatized and their lives disrupted. And just for example, one of our coalition partners was held in pretrial for 4 years based on false allegations that was made against him. Eventually the cases were dropped, but 4 years of his life disturbed, still traumatized to this day. And so all this bill is seeking to do is create a review process to ensure that the facts are true. For the foregoing reasons, the ACLU of Maryland urges a favorable report on Senate Bill 567. Thank you.
Thank you, Mr. Chair. 2 questions to the gentleman right there. I'm sorry, I don't remember your name. I believe I heard you say that if for some reason a law enforcement officer doesn't file the charges, then the victim could go to a commissioner?
Yes, so this bill would still allow anybody to go to the commissioner and apply for a statement of charges. The only thing it would change is in that situation, a commissioner could not issue an arrest warrant. Instead, they would issue a summons for the individual to come to court. So this does not prohibit a situation where an individual makes a complaint to the police choose not to act on it, and they feel, hey, there actually is a case here. It just would prohibit a warrant from issuing in that situation, and then the state's attorney's office would be able to screen the charge and decide whether this is a case they wish to pursue or not.
Okay, and following up on that, I'm looking at the testimony from MCASA, and they are in opposition to the bill. And they say in 4th-degree sex offense cases and even some felony sexual assault cases, sometimes law enforcement won't even make the report. So we were talking about that. But then they say it's important, it's another necessity for survivors to be able to get that warrant rather than just a summons. So how would you respond to that?
I would suggest that the protection that is available to them if the police fail to act is filing for a protective or a peace order. There's still legal protection to individuals that can show that they are in danger, but not necessarily the issuance of a warrant without any investigation or screening.
Thank you.
Thank you.
Thank you, Mr. Chair. My question, I think it's simple. When did we give district court commissioners this ability? And was that recent? 60, 80 years? Comes from the common law?
I do not know the answer to that. I'm sorry.
Okay.
And I looked to my panel. I don't think anybody. No, I don't know.
Okay. Thank you. Okay.
I must admit, this is the first time, I'm not a criminal lawyer, so this is the first time I've run into this. So your concern is that private citizens who go to commissioners take the time and effort to go down to the commissioner and fill out an affidavit, which apparently is required, and then stand before the commissioner to ask for the warrant, that they are lying to the commissioners. What is the penalty if somebody fills out a false affidavit?
6 months, I believe, is the current penalty. However, I will say that when this bill was first brought to me, it was Delegate Addison's bill, which is somewhat different. Hers seeks to increase the 6-month penalty to 1 year, whereas my bill mentions nothing about it because I figured 6 months was sufficient for someone who was caught with making a false statement.
Okay, I carry no brief for someone who files a false affidavit. I think they ought to have the book thrown at them, frankly. But I'm not sure why we would want to change the law because there are some miscreant citizens who file false affidavits to prevent all citizens from going in to try to obtain a warrant if they feel one is necessary.
I believe the public defender talked about it. There was an article that was in the paper, I believe, last year where a woman here in Baltimore went through this process, filed her statement of charges, and there was a famous music performer who had not stepped foot into Baltimore, and that was temporarily, he was arrested because of what this woman filed. So
what happened to the woman?
You would have to speak to Baltimore City State's attorneys about that. I'm not exactly certain, but I do know that the performer who was arrested was let go.
Okay, I do see that in the fiscal note, they indicate that a lot of these things are filed. Non-police applications for statement of charges in fiscal year 2024, there were nearly 20,000 of them. And the number of arrest warrants issued by the district court commissioners to everyone, 25,000. So what's going to happen when people who have been going to the commissioners to file affidavits in order to get warrants issued are told you can't file them anymore?
Let me say this. If you also look within the testimony that was provided, our state's attorney from Baltimore County, he supports the legislation.
I'm looking forward to talking with him in a minute.
So, and again, I think you would find other state's attorneys here, but for the fact that we disagree on penalties, they want the authority. Again, you're talking about someone's freedom. And a weaponization of a process that has been abused by people. And your state's attorneys, they go to law school. They know how to deal with this stuff. Police officers, they know how. They've been trained in probable cause. District court commissioners, just by looking at the way things have been weaponized, probably aren't the best choice for issuing arrest warrants without the overview of or the inclusion of a state's attorney or police officer. That's all that this bill does, is it includes those professionals in the process so that a district court commissioner has that second look prior to that issuance of that arrest warrant.
All right, well, thank you for your answers.
You're welcome.
All right, further questions from the committee? All right, thank you very much.
Thank you very
all.
much.
All right, we'll move on to the next panel. Samuel Buckley, Beverly John, Don Dalton, and then if Mujahideen Mohammed.
Welcome. Thank you. Thank you, Chair and committee. My name is Samuel Buckley. I am a 16-year educator here in the state of Maryland. I served in the role of teacher, assistant principal, and principal in multiple districts ranging from Baltimore City Schools to Carroll County Schools to Baltimore County Schools to last year in Anne Arundel County Schools. Last year, I was awarded a award from Governor Wes Moore for a Purple Star Principal, award for my work in the school system. I am a father of 4. I have a daughter who's in the Navy, a son in college, and 2 elementary school kids. My career has taken me really far. Last year, I was promoted to middle school principal to high school principal on June 21st. On July 1st, as I was cleaning out my office at my previous job to start my new job within a couple of days, I was a principal at MacArthur Middle School in Anne Arundel County on the Fort Meade Army Base, and I was stopped by the security at the gate. They told me that I had a security alert and that I cannot go on to the base to clean out my office, as I was going to start a new job within a couple of days. I then learned that there was a warrant for my arrest. So, as a 16-year educator who's never had an orange jumpsuit on, to go and have everything stripped away from me. And 3 months later, I go to court and charges are dismissed, and then I can get my life back, only to the next day, the allegations were brought up again and the person refiled, and I was arrested again because a commissioner signed the warrant for my arrest. So not only did I go to court and I spent thousands of dollars on a lawyer for charges to be dismissed, but then they refiled the next day, and then I was rearrested. Last week in Baltimore County, I asked for a jury trial, and I was exonerated of all charges, found not guilty. So 7 months of my life has been taken away because someone filed false charges. In June of 24, someone filed false charges and said I did something to them in November of 2023, 7 months earlier. And they did it the day after I was appointed to a principalship in Baltimore City Public Schools. And that is not fair. So now I'm at the point, yes, I can get an expungement, but I've wasted 7 months of my life because someone went down to a court commissioner and said that this person did this to me. So I am in full support of Bill 567. So not only Samuel Buckley, but everybody else who've been wrongfully accused of things, it can go through the proper channels and be investigated. Thank you.
Thank you very much, Mr. Buckley. I know we have a question. We probably have a pending question from you, but let's go ahead and hear the next witness, and then we'll come back, give you a little bit more grace, because I know you're sharing a personal experience, so I appreciate that. Sir.
Good afternoon. I want to thank the members of the committee. For the record, my name is Mujahid Muhammad. I am a businessman who has businesses from Carroll County through Baltimore to Prince George's County. And one thing that I find, no matter what county that I'm in, is that false allegations ruin lives. I have hundreds of employees throughout the state. I took my time today as a businessman to come and advocate for this bill because there are small nuances in law that create gaps. And for most, they don't have the ability to have a lawyer just there to be able to fill those gaps. The challenge here is that this gap creates harm for individuals, including myself. I have been under investigation due to this from the same person 12 different times. And there is no way for it to stop. The blessing is that I have a lawyer, and I don't have to show up. And every time it's found as being unsubstantiated. I actually am under one right now. The blessing is I have a lawyer. The rest of the state of Maryland, Most of them don't have the ability to do what I do, but they have one thing that's extremely important. They have you. They have the legislator who makes sure that when there's harm happening to Marylanders, we have someone who we put in office to assure that our needs are being met. So today, I come here as a supporter and as a businessman to be able to say, please protect all Marylanders from the harm that this gap has created. Thank you.
Thank you very much. Senator Muse.
This question that I never really gave this a lot of thought. Someone can simply go down and say, you stole, I can say, you stole my car, you kicked my door and broke into my house, and a warrant is automatically written?
Thank you for the question, Senator. I'll use this as an example. And the brother to my right actually does not know this. I'm actually one of the school commissioners for Baltimore City Schools. Okay. And when this happens, even as a school system, that person's job, there are things that we cannot allow in our schools. So when someone gets a particular charge, we have to remove them from our schools. We cannot put our children at risk. So yes, when this happens, there is a warrant and the person is arrested. And that warrant is not based on police investigation. That's the most important piece here. The warrant is executed based on a claim being made prior to any investigation happening. And that's where the gap is. And I think that that's what this bill is asking us to do, be able to fill that gap for a period. And I would hope that the state's attorney's office can maybe add a little bit more. The period is a very short amount of time just to investigate enough to make sure this doesn't happen.
That makes perfect sense. Thank you.
Thank you.
Chairman, my question is for Mr. Buckley. First, thank you for sharing your personal story and being willing to bring us the impact of what it's like in someone's life when this happens. I want to dovetail on the question that was just asked in the response we got previously. You mentioned that there were 7 months of your life where you were waiting to have your final day in court so that you could be exonerated.
Yes.
Could you help us understand what those collateral impacts were during that time?
Well, of course, even though I was appointed as principal in another school district, I was not allowed to take that particular position. In addition, the school that I was already a principal at, which was in Anne Arundel County Public Schools, I was released from my position in that role as principal as well. So the last 7 months has been like, I have a son in college. I'm responsible for paying his tuition. Sorry. I have 2 other kids that I'm responsible for who are elementary school age. I have bills to pay. I cannot obtain employment because of this background. And I've served kids for over 16 years, all throughout this state. And you're telling me anyone can just walk down the street and say, Mr. Buckley did this to you, Mr. Buckley did this to me 7 months ago, with no evidence, no anything, and I'm arrested, my reputation is ruined, I'm not able to support myself or my family, and there's nothing that happens to the other person. So yes, they can be jailed for up to 6 months, but 9 times out of 10, that does not happen. And the ironic thing is when I came down here last week, I sat right next to the state's attorney for Baltimore County, and we were having a great conversation about football, about Super Bowl, all that good stuff. And he had no idea that his office was responsible for me not having employment for the past 7 months. Nobody investigated or anything. So anybody can just go down to the commissioner's office and say, this person did this to you, and then everything is stripped away from me. Everything that I worked hard for. I am a decorated principal in this state I was awarded last spring by Governor Moore himself. And you tell me that all my work goes in vain because one person makes a false allegation 7 months prior?
Thank you. I'm going to ask you to speculate just a little bit, but if the evidence that you had at trial that resulted in you being exonerated, if this bill were law and that evidence was reviewed perhaps by a state, if the evidence were reviewed according to the foundations of the bill, do you believe that you would have not suffered those consequences for the intervening 7 months and that this could have been dealt with quickly?
Yes, absolutely. I think that the state's attorney would have had the opportunity to look at the plaintiff evidence and then my evidence, and they could see that these were false allegations. In fact, that happened in October 11th. On October 11th of last year, the state's attorney, we went to court, state's attorney dropped the case before we even picked the jury because there was no evidence. Only for the individual to go and file the next day on October the 12th. So then it starts all over. So the state's attorney dismisses it one day, the individual refiles the next day, and the commissioner issues a warrant. So I have to go through the whole process all over again.
Thank you for your testimony.
Thank you.
Thank you, Mr. Chair.
Chair, Mr. Buckley, I find this whole thing to be utterly appalling. I will say I've been on this committee now for 7 years, and this is the first time that I've become aware of this problem, which is shocking in and of itself. So let me ask you this. Did you ever get copies of these affidavits that were filed by the person who accused you?
Once I was arrested. So just to give you a timeline, on June 21st, I was appointed as principal in Baltimore City Schools. On June 22nd, that individual, I guess, must have found out I was appointed, went down to file the charges. I wasn't arrested until July the 1st when I was trying to get onto base, onto the Fort Meade Army base, and there was a security alert, and that's when I found out about the warrant. So I knew nothing about it.
And then what did you, once you saw the affidavit and realized the charges were false?
Yes.
Did you take any action? Did you yourself go to see the state's attorney and say this is an outrage? Did you hire private counsel?
Yes, I
hired. To bring charges against the person who filed these false charges against you?
Yes, so I hired, well, first and foremost, I had to turn myself in. So I went through the process of turning myself in. I saw a court commissioner. The court commissioner said, read the statement of charges. I was released on my own recon. And then after that, I sought private counsel. And then once we went through the whole legal process, so yes, I can civilly sue the person, but I can't sue them for 3 years because I want my expungement. So the thing is, if I get my expungement now, in which I've already filed, the thing is, I can't sue the person for anything for 3 years. That's the way the law is written. So the thing is, they get off scot-free, and no one does anything about it.
So you have secured legal counsel of your own. Well, I wish you the best of luck with your lawsuit because you've been treated foully, and the system of justice in Maryland ought to be in a position to make you whole at the end of this time for what you've suffered. And frankly, the state's attorney ought to bring criminal charges against the person who filed the false affidavit and ought to put that person in jail.
Yeah, but...
Thank you.
Thank you.
Thank you, Mr. Chair. I apologize for coming in late. I don't know, I'm appalled at when this happened. I'll just say that right up front. The allegations that were made, did you say what those were against you? I'm just asking. I don't need to know. I mean, I don't know if you had already said it or not, or if you just rather, you don't have to bring them up. But when I hear certain allegations and I hear that the district court commissioners issue a warrant and then the person gets, after a hearing in front of a judge, they get PR, personal recognizance, it does make one wonder for the severity or for the actions that happen to the person after the fact, right? So I've seen this throughout my career where people, they've kind of peeled back on how much law enforcement, ironically, has been able to do for certain instances, and they want the victims to go and apply for their own charges. And they've encouraged this, right? And now we have victims, now we have a pattern where victims are going and they may make erroneous statements that are not easily taken back. And one of the failing policies, if you will, that I see in this body is that there's no accountability for those that make those type of allegations because, well, they've been a victim and we don't want to have them charged because they went and have tried to ruin said person's life. And that's where my issue, I mean, this body should really take action and say, look, if you make a malicious false allegation, there should be consequences for that. And it shouldn't have to be civilly to wait 3 years. And the expungement should come in a much more readily streamlined fashion. So I would like to see and maybe even speak with the bill sponsor. Okay. But I think that that's something else that we've got to really look at and consider. I mean, wouldn't you agree with that, that this is, someone's been personally affected by it?
Yes.
Would you agree with that?
Yes, 100%.
I appreciate you sharing your story and being here, and thank you.
All right. Thank you very much, Senator Folden. For further questions from the committee? Okay. Thank you, gentlemen. Thank you both very much. Thank you. All right. Is Tamara McKinney? And then we have Christine DeForest testifying virtually. And then we'll switch over to our opposition panel. She's not here. All right, so Ms. DeForest not here. Is Tamara McKinney here? Okay, with that, then we'll switch over to Ms. Ruth for the opposition.
Good afternoon, Mr. Chair, members of the committee. My name is Laurie Ruth. I'm the Public Policy Director at the Maryland Network Against Domestic Violence. And, you know, it's hard to stand up and hear those stories. And those things happen to our victims as well. The savvy abuser knows that they can go to the commissioner, and if they allege certain things, they are more likely to get a warrant than a summons. But I did this testimony last week on HB 21 over there, which is somewhat similar. As Senator Sidnor said, it's just different about the false statement and the misdemeanor there. And it didn't occur to me until after the hearing that the entire discussion, there were 4 state's attorneys at the table and the entire judiciary panel of legislators, everybody was talking about it as if the person who comes in and files the charges comes in and says, I want a warrant, not a summons. It's actually the commissioner's job to decide based on the facts, and you see in the fiscal note what they have to consider. And the problem we have with victims not being able to go and do this, and if a commissioner decides and a warrant is warranted, although that's awkward to say, that's what should happen. It's because they are in danger. It's because the time when they are trying to leave their abuser is the most dangerous for them. And so to take away this avenue for them to achieve safety is really dangerous. A summons, it gets served much slower. There's not priority. There is no immediate investigation done. It leaves a real victim in real danger. I wanted to respond to just a couple of other things. The fiscal note says, oh, this wouldn't be too expensive, but I don't know of a law enforcement agency that wants to see their officers staying for hours at the commissioner's office and not being on the street. In addition, what we have found for years and years is that even when you call 911, often the officers are not willing to even make an incident report, much less an arrest report, much less escort the person to the commissioner. So that's a real problem. What I said across the street, if you'll just indulge me for one moment, Mr. Chair, is a lot of what is described is a problem with the commissioner system as a whole. And I'm not here to tell you all to reform that system, but this bill is not going to fix some of those inherent problems of having the commissioners making the decision. And just to answer one other question, I've been doing this work since 2008, and at least since then, the commissioners have been allowed to do this work. So it's been going on 20 years. I think Ms. Lennick might know the answer. She was around back when it changed. So I have a lot more to say, but with that, I'll just say we oppose the bill for these reasons.
Thank you very much. Senator Folden and then Senator Walsh-Reger.
Thank you, Mr. Chair. Thank you for coming and testifying. I just wanted to make sure that we're clear, and obviously either I missed it or it wasn't mentioned, but the domestic violence laws are very different as far as police actions and the time frame after, even if there's allegations of assault, are they not?
I don't know what you're referring to specifically. I'm sorry.
So if you go to, if Senator West and I have a little dust up and we get in a fight and police are summoned, but we're not actively fighting while you're in your presence, what are they going to do? What are they going to recommend to us?
They're going to tell you to go.
They're going to refer us to the commissioner.
To the commissioner.
Right, if you feel that way.
Either to file a statement of charges,
Right.
to seek a peace order or
Correct.
something.
And they'll write up a little report that says, hey, we responded, this is what each said. Okay. So domestic violence is different though. So in domestic violence, you have domestic partnership. Is it not true that the police then, even after an assault, can make an on-site arrest, even though they didn't witness it?
The fiscal note goes through the statute, goes through what a commissioner has to find. They have to find that the defendant
I'm not talking about the commissioner. I'm talking about law enforcement responding to the scene.
I am not versed in law enforcement as well as you are. There are circumstances under which law enforcement may arrest without a warrant.
I'm sorry, who do you work for? Who do you represent?
I represent the Maryland Network Against Domestic Violence. I've always been a civil attorney, so I apologize. I don't have a lot of.
Okay, so the domestic violence laws are different as far as law enforcement response. So I was just curious how you were coming in for the DV part of this and trying to explain, because law enforcement handles domestic violence laws differently. I mean, they can charge somebody up to 48 hours after the incident.
Yeah,
and make a custodial arrest.
They can, but they don't, and it doesn't.
I wouldn't say that they don't. I would say that it's about reporting, though. Like, people have to report it, and if they report it within those first 2 days, they have that authority to make it.
But there are
a warrantless
reasons
arrest.
that they don't at times. There are reasons that they don't call 911 at times.
So you're talking about the victims not calling.
Yes.
Okay, I understand that. And then you're saying that after that, is that what you're talking about? Is after that initial window, after the act, and then sometime later them
Well,
applying
this
for charges?
bill is talking about going to the commissioner and seeking charge, making a statement of charges and either an arrest warrant.
You are having a complimentary conversation, but you're talking past each other just a little bit. So the fact pattern presented was intriguing for a lot of people. And so I think what you're hinting or squinting toward is why that fact pattern that we were just presented with may not make immediate intuitive sense. And so he's going to walk you through, in a DV case, some of the machinations of what can happen, and arrests can be made. And
right, and that's what I thought you were already going to be versed on. So
I'm sorry, that helps, because I'm not getting it clearly.
I thought you'd have I thought you knew, coming from the Maryland, the Domestic Violence Coalition Against Domestic Violence would have been a little more familiar with that, so I'll just stop there.
You're right. There are circumstances where they can arrest in advance. I think that this bill doesn't necessarily address that, and I think that this is about sort of.
I guess what I was asking is what circumstances are you bringing forward representing the domestic violence that law enforcement isn't already taking, like law enforcement's doing it? So you're talking about the occurrences where they go out after the 48 hours?
No, I'm talking about the night of the incident or the next morning if they didn't call 911 the night before for safety reasons.
But they can still call within 48 hours and the police can still make the arrest, is what I'm saying.
That may be true. It's not how I've experienced with the hundreds of clients that I've had, that's not what happens.
Okay. No, I appreciate it. Thank you.
Yeah. And I'm sorry, I'm happy to have a talk with you and try and understand it better. I just am not.
Thank you, Mr. Chairman. I know the sponsor stepped out, but
I am having, I'm sorry, a lot of
I'm sorry, I can speak up. These new mics are not as loud as the old mics used to be. So first of all, thank you to the sponsor for ringing the bill and the two gentlemen who I think are outside I really appreciated their stories, which were deeply moving. I wanted to touch on one thing that was previously touched on that Senator Love brought up, as well as one thing that wasn't touched on. Senator Love asked a hypo regarding a sexual assault, and I was a little taken aback at the response by the Office of the Public Defender that the appropriate remedy was a civil peace order to a horrible criminal act. And so I guess my question is, do you think that's the appropriate remedy in those circumstances? What should a victim of a sexual assault do in those circumstances?
So this is what the commissioner does, right? The citizen goes down and says, these are the facts that happened to me. And if it's horrific and dangerous, if there's a weapon involved, if the person is in danger, then they issue the warrant versus the summons. And just to be clear, there are ways to get that warrant quashed or changed. It's in the existing law. And that's the time when that victim is in the most danger. So here's the issue. It's awful that these gentlemen have had one filed and then one filed or however many filed. It is a misuse of the process. I fully acknowledge that. But the commissioners are only allowed to look at what's on the four squares in front of them. So they don't know that his case was dismissed the day before and she walked back in and filed the day after it was dismissed. They don't know that this is the 12th one that person, has filed against the person and that they've all been dismissed. On the House side, we had a long conversation about perjury and enforcement to try to quash or, reduce the number of people who are misusing the system. And I fully support that. But the state's attorney from Baltimore City and another state's attorney as well both said, oh, well, we don't really charge perjury. It's too hard to do. I'm shorthanding, but that was the message that I got. So there does not seem to be any accountability for the people who make false charges with the commissioner, and they say enough facts that the commissioner says, this one's a warrant, not a summons. But domestic violence victims don't go in saying, I want a warrant. And the commissioner says, well, maybe just a summons. Oh, no, I don't want a summons. I want a warrant. This is the commissioner making those decisions.
And then one thing that wasn't discussed here that I think is important to this conversation, we had on an unrelated bill, an ICE field agent here or the director of Maryland for ICE who said in no uncertain terms that the nature of enforcement is changing. And that impacts people's trust in law enforcement. I represent a large undocumented immigrant population, and I'm sure you've seen victims of domestic violence. And so can you tell us how this particular piece of legislation may impact domestic violence victims who are undocumented and may feel uncomfortable calling police because of that fact? They are already afraid. That particular population in today's world is more afraid than I've ever seen in my lifetime, really. And they come from countries often where law enforcement is not a place they trust or think is going to help them. So they're already up against all of that at the time. I think the hope would be, if I'm being sort of idealistic, is that maybe they don't call 911 that night because of all of the threats. They're going to call ICE and have them deported. There are special threats that are made against the undocumented population that are especially scary. But maybe the next day they call, House of Ruth, or they call the Women's Law Center or one of the providers who says, this is how it works. We will be by your side and help you. So now let's go. And if there is an opportunity, we go to we may talk to the state's attorney rather than just sending them off to the commissioner, who's just another sort of law enforcement entity to many of the citizens. And they're located in the courthouses, which many of them don't want to walk into. And so it's a terrible conundrum for how a victim can achieve safety. And that's our concern here. You take away the warrant possibility from a citizen going in on their own, those are the most dangerous cases. They're not the ones where it's a summons. And just to correct another thing that was said that I believe either Senator Henson or Senator Love asked one of these gentlemen a question, it's not any crime. It's not I stole a car. It's not anything. If you look in the fiscal note, it has to fit within those factors for the commissioner consider or to issue a warrant. So it really is about violence, weapons. It's the serious cases, and removing this from our clients is potentially fatal for them.
A question based on what you've just said. If someone files this 12 times, should they be able to just walk away from it with nothing there to really protect them? Because what I'm seeing, and I just got stats from my county, that this happens all the time. Now, perjury is for that is like 6 months, right? Mm-hmm. How can a state, I mean, what do you think, and I'll make my personal thing, a prosecutor can have the resources to pick up a person, but not the resources to charge a person for perjury and say, oh, we don't usually do that. I think that is totally inexcusable. I sharply rebuke any state's attorney who would take that position and think that we need to do something here in the legislature to say not may, but shall. They have to. If I did it, you know.
Senator, I don't disagree with you. I mean, watch the hearing from SB 21 last week in Judiciary. Those state's attorneys said it's really complicated. We don't generally charge perjury. That was their testimony.
It's up to us to uncomplicate it, because justice is not dependent on whether it's too complicated for someone to do their job. It's dependent on justice being the same for everyone.
I agree.
That's inexcusable. They are wrong for doing that, and they need to go back to their association and make some recommendation to us to clarify this, because this can go. We've had some legislators that has happened to.
I know,
people
and
can
it
get
happens
mad
to our
at
clients,
you as a
as I
legislator
said.
and go down and do that, knowing that they can just walk scot-free after damaging your life for thousands and thousands of dollars. It's inexcusable, it's wrong, and we here in the legislature need to fix that.
Right. So years ago, I
understand your position.
Right.
But
years ago, I sat on a committee that was trying to allow commissioners to see more materials than they see. And it was, the kibosh was put on it by Chief Judge Morrissey. And so I thought that was a good idea. Let the commissioners look up the person who's in front of them and see if they've filed 5, 6, 7 against the same person, and let them consider that. The committee disbanded, and nothing ever happened. But that's a commissioner issue.
That's ridiculous. Thank you. Thank you.
All right, further questions from the committee? Seeing none, thank you very much.
Thank you.
All right, with that, that'll conclude the hearing for Senate Bill 567. We'll now move on to Senator McKay with Senate Bill 398.
Thank you, Mr. Chairman. Thank you, committee. As you well know, I'm a second chance guy. I do hire a lot of second chance people. I'm a firm believer in choices have consequences, but once you have paid your debt to society, or you have acknowledged and you've been tried in a court of law, you should be given a fresh chance and a second look to make sure that what you have done doesn't have lasting repercussions. Now, the following of one of William Shakespeare's quotes that reflects the idea of a second chance or a fresh start. Comes from The Tempest, Act 2, Scene 1. What's past is prologue. Now, this line suggests that everything that has happened before is merely a setup for what comes next, implying the possibilities for a new beginning and opportunities. Now, Senate Bill 398 would expunge most misdemeanor convictions after 3 years, doing it automatically. I tend to believe that this panel is very, very diverse. And as it was noted to me, a lot of times you would not see these panelists in favor of a particular bill. So please note as they come up and testify. Look, there is no doubt we have we need to relieve the labor shortage that we have. We need to help our employers. We need to help our workforce and our economy. But more especially, we need to make sure that these returning citizens have an opportunity to be successful and be positive and, for lack of better words, doing the right thing. So I urge a favorable report of Senate Bill 398, and I'm not sure who wants to go next.
I was actually quite impressed by your panel composition.
That's what I'm telling you. Ladies first. No, you want to go?
Good afternoon, Mr. Chair, members of the committee. I don't have a Shakespeare quote. I'm not sure I could spell the name.
Next.
And that's probably in part, as many of you on this committee know, I grew up in a small town just west of Savannah, Georgia. And I came to Maryland for opportunity. And at the Maryland Chamber of Commerce, we are supportive of economic opportunity, because without economic opportunity, we don't have economic mobility. And it is frustrating to think that people are kept from accessing economic opportunity and job and employment prospects because of something on their record. And so the business community at the Chamber is in support of Senator McKay's bill. As I mentioned earlier on the governor's bill, the state is ranked last year. We were 49th in job growth. We need more jobs. We need more economic opportunity. And we think that this bill is a good step in that direction. And so for that reason, we are in support of the bill. And Mr. Chair, I have like 3 other bill hearings. Could I please be excused? I apologize. Thank you.
Good afternoon, members of the committee. My name is Meredith Gerard. I'm Executive Director at Shore Legal Access. We provide free legal representation for people who otherwise couldn't afford an attorney, and we represent people in their criminal record expungement petitions. We do this through our network of volunteers who do the research. Sometimes they have to call the courthouse, get extra information. They prepare the petitions. They work with the client to get them signed and counsel them. Multiple steps to the petition-based expungement system. We have clients like a mother of 3 who's seeking to clear a charge, just a charge, not a conviction, that was many years ago that she needs to have off of her record so that she can get her nursing certificate. So many clients who would benefit, 407,000 Marylanders who would benefit from automatic expungement. The petition-based system is simply not very efficient for organizations like ours. We would much prefer to spend our very limited resources on some of the other burning cases that we have to help protect people's rights. We also, on the Eastern Shore, I just want to share with you that we have a disproportionately large number of people who are involved with the criminal justice system. The rate of incarceration there is twice that of the rest of the state. So automated expungement would significantly reduce the burden that people who have earned and deserve to have their records cleared, while also reducing the cost and the time and the resources required by my organization, required by the current petition-based system. So for these reasons, we urge your support. Thank you.
Good afternoon, members of the committee. Heather Warnken from the Center for Criminal Justice Reform at the University of Baltimore School of Law, here in strong support of Senate Bill 398. which would provide much-needed relief for hundreds of thousands of Marylanders burdened by old records. So right now, approximately 1 million people in Maryland, 22% of the total adult population, have a record, which, as we've been hearing all day, creates lifelong barriers to jobs, housing, economic stability, and so much more. So we already have this critical relief for these barriers available for those who meet the criteria set by this body, yet under the current system, only 2% of those eligible ever receive it. And at this rate, it would take 86 years to clear all of these already eligible convictions. This is just an unworkable and unjust timeline. So as we've been hearing, Clean Slate would automate the sealing of approximately 407,000 eligible records, 40% of people with a record in Maryland, allowing these misdemeanors to be sealed in the allotted time. This means real second chances for Marylanders who have already served their time and who are trying to move forward and who, again, our laws have already determined should be eligible to do so. But this bill isn't just about making that relief real for those who are legally entitled to it. It also means a stronger economy. Each year, Maryland loses an estimated $1.5 billion in taxable income due to the barriers created by these clearable convictions. And that number actually doesn't even account for the economic loss suffered by those with non-conviction records who also face similar job barriers. Clean Slate would provide an opportunity to strengthen Maryland's workforce and drive the economic growth that we desperately need. It's a common sense policy, and we urge a favorable report.
Good afternoon. My name is Eric Galley, and I'm here today on behalf of Shore Legal Access and the Clean Slate Initiative. And I have to say, it has been many years before I have been before the esteemed JPR Committee. I think it was back in the old building. And I think the only one who was here was then Delegate Muse. I haven't testified since you all have been here, so it's great to be here. And I just wanted to note a couple of things. I'm the cleanup hitter. Number one, and most important, the bill says expungement, but under the common understanding, what we're really doing is sealing the records electronically. We are not completely destroying the records. There are cases where people need their written record. The judges will have access to this. We're really talking about shielding the record on the electronic databases that hirers and housing people use to look people up. So think of it more as record sealing than as expungement. We stayed with the term because it was the term that was used during cannabis, and this year, doing a very different bill, we wanted to mirror what you all did with cannabis. So that's that. And I also wanted to note that in your written, you have more support from business community, Greater Baltimore Committee, Salisbury Area Chamber of Commerce, and I missed somebody, but you get the idea here. There's a lot of businesses here, and they're all telling you the same thing, that they have jobs open and that they want to hire people and that there are folks available for these jobs, but they can't get them because they have this barrier. If we clear this barrier, we can turn people into taxpayers, get more revenue, and it'll be really good for the state. So with that, I urge a favorable report.
Thank you. I think this is going to be the first time, not the last, but the first time that we're going to end up having a McKay-Muse bill. I'm definitely signing on to this bill one way or the other. And to our committee, probably the longest serving person from, in 1994, the same issues, and to see this committee making the changes that we should have made 13 years ago. I am proud to be a part of this committee, and I thank you for what you're doing, moving us toward. And I think that, I guess my only question is that the bill sponsor did a good job. Isn't that so? All right, thank you. Thank you, sir.
Senator West. Thank you, Mr. Chair. I got a question for Ms. Warnken. By the way, I had only the highest respect for your father. He was a wonderful man. So the state's attorney's opposition emphasis the fact that under this bill, it appears that a person automatically gets their case expunged, even though the person may not currently be entitled to the expungement because the individual has been subsequently convicted of another offense or is currently a defendant in a pending case. So do you think that that is a good way of approaching it, or maybe an amendment should be made to this bill to exclude from the automatic expungement people who have subsequently been convicted of other offenses or are currently defendants in pending cases?
So I think really a clarification is in order, because this is meant to automate what people would be eligible for anyway. So if there are new charges or things that would be cause for a state's attorney to be able to object, that's a different situation. But this is really just about this small category of misdemeanors that are absolutely clearable. And really, this is a very incremental baby step bill, and there's been a lot of dialogue, but I'm sure the coalition and others would be happy to discuss that further with the state's attorneys. I don't know if Meredith or Eric want to jump in.
So it sounds like we're on the same page here. We just need to maybe add some clarifying language to the bill to make sure that inadvertently we're not going to be granting automatic expungements if someone is currently, there's a pending case involving the same kind of conduct against the person.
But I would just add, Senator, that if you did want to do that, you could do that in the expungement law. What we're trying to do here is not change people's eligibility for expungement. We're just trying to automate the process.
Okay. Well, then let me ask, under this bill, if a person were currently a defendant in a pending case involving the same sort of misdemeanor, would this bill automatically expunge the prior misdemeanor?
Well, this bill wouldn't decide that. Again, it would be an automated process. So if you wanted to if you thought that was an issue and you wanted to fix it, you would have to go into the rest of the expungement law and clear up the eligibility for the expungement.
Okay, thanks.
Yeah, just to sort of double down on the clarification that Mr. Galley made earlier about shielding versus expungement, this wouldn't destroy the existence of that record. So, within the criminal legal system, they would see that misdemeanor in the instance of new charges. This is about shielding to not have it erect these barriers for all these other purposes. Yeah.
Questions from the committee? Seeing none, thank you very much. All right, next we'll hear from Zachary Alberts. Is Chris Dew still here? Yep. Chris Dew. Christopher Sweeney.
I'll go first.
And Brandon Hatton. And then Mark Woodard, if you want to come on up, I think that'll round us out.
So I'll go ahead and get started. Christopher Dews from Cornerstone, representing both the Center for Urban Families and Out for Justice. So yeah, we think this is an interesting piece of legislation. We think it's pretty solid. Senator West, I think that I know the members of Clean Slate, and I know our coalition would be happy to kind of further dive into what that would look like. I just want to also be clear about the process and how this would work. Just to be clear, because I don't think this was said, this is not automatically seal any charge that is second-degree assault, or it doesn't touch anything domestically related. I just want to make sure that's on the record. And also, just the process, starting in August 2027, so this doesn't start anytime in the immediate future, August 2027, a monthly report will be sent out. And then in that report, there will be determination as to what charges will be eligible for the sealing process. That will then get sent from the judiciary to the department, or maybe it's in the reverse, but the bottom line is they're going to communicate with each other. And then after that communication is made, a 30-day notice will be sent out, and then they'll be able to get that record sealed. So I just want to let you know how the automation process works. So first, there's the notification of whether it's eligible. That information gets sent to DPSES, and then DPSES will then move to seal that record. I also just wanted to highlight that this is only for non-convictions in 10-105 and for a select number of misdemeanors that are already eligible. And the last thing I wanted to say was we have a lot of other supporters. I don't think this was mentioned, but I believe State's Attorney Ivan Bates has also submitted written testimony in favor of this. And I know that we have an entire Out for Justice team who are actually wearing our clean slate shirts today to show our support for this piece of legislation as well. So I will, with that, proceed and happy to answer any technical questions you guys have about the piece of legislation. Thank you. Anybody wants to go? Take time.
Good afternoon, everybody. My name is Omani Placid, Program Coordinator for the Baltimore City Health Department in partnership with YO Baltimore, a youth opportunity workforce development center under the Mayor's Office of Employment Development. And I am a resident of the 40th District. I stand here before you today in strong support of Senate Bill 398, which would automate the expungement process for eligible misdemeanors in Maryland. I know firsthand how a criminal record, even for a minor offense, can derail a person's future. My charge wasn't for a serious crime, yet it shut doors that should have been open to me. I lost access to gig economy work and was blocked from becoming a correctional officer, not because of who I am, but because of what was on paper. I was lucky, right? Someone that knew me by the name of Tavon Thomas saw me for more than what my past mistakes had to say and allowed for me to become a youth organizer. Now, my job, rather my duty, is to help young people, many who, like me, made mistakes and are trying to build a better future for themselves. But here's the truth. Most of them don't even know what expungements are or if they're possible. They don't know if their record could be cleared. They don't have the resources to navigate the process, and even if they do, the cost alone can be the barrier for them. How can we expect someone, a young person, to afford an expungement when their record keeps them from getting a good, decent paying job in the first place? A single mistake made at 18 shouldn't determine your entire life. It shouldn't be why someone is stuck in a cycle of low-wage jobs with no room for growth. I know my life could have been way different if I didn't have the proper support at the right time. That's why I'm here today, to fight for those thousands of people like me who weren't as lucky. Senate Bill 398 is a chance to right a wrong in our system, to remove unnecessary barriers and give people a real shot at redemption. I urge you to support this bill. A favorable report doesn't just change policies, it changes lives. Thank you all. And I'm here for any questions as well. Okay, thank you. Sure.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. Mark Woodard on behalf of the Job Opportunities Task Force in support of Senate Bill 398. You've heard some very compelling testimony. I particularly want to concur with the testimony from the Maryland Chamber and from the University of Baltimore Law School. There is clearly, first and foremost, we need to clear the record of people who deserve to have whatever prior misdemeanor offenses expunged. And one of the most important reasons, not the only one of the most important reasons is so they can get on with their life, get a job, contribute to their employer, be part of the workforce, be taxpayers, and be making a contribution again in their life. And we commend Senator McKay for bringing this legislation forward and for all the other advocates who are here today in support of this bill. One particular example from my organization, we have a training program called Better You. People go through that training program and they're eligible to do work in the construction industry. I've been told by the person that heads that program, far too often somebody is hired on one day and they're fired the next because it comes out they have a criminal background. This bill is a step in the right direction. We urge a favorable report and we thank you for your consideration.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. My name is Daniel Okonkwo. I'm here representing JPMorgan Chase. Thank you for the opportunity to testify on this. I'm standing in for Brandon Hatton. Senators, 1 in 3 Americans, roughly 80 million people, face barriers to employment due to arrest or conviction record. They represent what we would call, a waiting workforce. JP Morgan Chase is committed to giving people across the country a second chance. And in 2023, we hired more than 3,000 people with criminal records whose history had no bearing on the requirements of the job they were seeking. That's nearly 10% of the firm's new hires across the country. We believe that business has a role to play in helping more people share in the benefits of economic growth. But to achieve systemic change, we need improved public policy, including common sense measures like the one before you today. In Maryland, it is estimated that more than 400,000 people are eligible to have their records cleared, but very few pursue the complex, time-consuming, and costly process. That means that even after fulfilling their obligations to the justice system, people with criminal records often continue to be blocked from fully participating in the economy and their communities. By reducing barriers to employment for those with criminal records, clean slate legislation can play an important role in getting more talent into the labor market. States such as Pennsylvania, Utah, New York, Louisiana, Connecticut, New Jersey, Virginia, Colorado, and others have passed measures like this to automate the process of clearing or sealing eligible criminal records and opening pathways to careers. When someone cannot get their foot in the door to compete for a job, it hurts businesses and communities by limiting access to economic opportunity. We urge the legislature to pass clean legislation to help bolster the state's economy by more fully tapping into the talents of thousands of people who are currently underemployed or unemployed because of their past record. Thank you for the consideration. We urge a favorable report.
Good afternoon again, Mr. Chair, Vice Chair, and all members of the committee. I'm thankful for the opportunity to speak with you today. Again, my name is Chris Sweeney with Maryland Volunteer Lawyer Service. I've represented somewhere around 1,000 people seeking criminal record expungement, and quite often I'm met with a lot of surprise from my clients when I'm sitting down and reviewing criminal records with them. People say things like, "This happened 20 years ago. I didn't know that this was going to show up on my record," or perhaps even worse, "All these charges against me were dropped," or even "I was acquitted of any wrongdoing. I had no idea that this was still going to be coming up on background checks." And I think these are very reasonable questions, and these folks are very logically under the belief that this was gone. There's an impression in the community that these things do drop off without any kind of proactive activity from the person because it was so long ago or because they were never even found guilty of any crime. Unfortunately, I don't really have a good answer when my clients ask me that because it's just kind of, that's the way the law is. But why does it have to be this way? This legislature has already set out very clear requirements for what is and is not eligible for expungement. It's very concise and logical. There's really not a lot of gray area in the eligibility. There's not really a lot of opportunity for judicial discretion or debate. It's a yes or no kind of plug in what happened in the case, the outcome. It's either eligible or it's not. So that's just to say it's something that could be automated with relative ease. And I think in the long run, automatic expungement would clear up a lot of resources in the courts. There's thousands of petitions being filed every year. Ultimately, it's going to have a just outcome for those who are living with these records. So thank you very much for the opportunity today. I urge a favorable report.
All right, thank you very much. Questions from the committee? JP Morgan Chase is looking for some awesome investment opportunities. We've got this case management system for state's attorneys that needs a little help, and we've got there is a hefty fiscal note on this one. So maybe there's a Jamie Dimon can come down and stroke a nice check for us, get us on the right direction. No, just kidding. No, not really. But seriously, yeah, they're not asking for a commitment just yet. But really, thank you very much for the testimony. We look forward to working on this. But thank you all very much. This is great.
Thank you.
Thanks. All right, sweet. I think that was him. That was Omani in the red shirt. Thank you very much. and then Mark did that, and then Heather will. I think we're good. Have I missed anyone that wishes to testify on this?
There's Karen Clark and there's unfavorable.
Karen Clark, I think that happened. All right. So then we have, we'll switch to the opposition panel, and that's Mr. Cox.
Not sure I've been called a panel before. I'm John, Bill 398. I won't be able to get all I want to say within 2 minutes. I'll do my best to try to hit some bullet points. With all due respect, this is not a shielding. It's been presented as a shielding. It's not. The word is expunge in the bill, and it expunges, within the definition of expunge, it includes removing all reference to specified criminal case from the central repository. That's the criminal justice information system. This is an expungement. If in a circumstance where I would stand up in a courtroom and say, this person has something that's been automatically expunged, I stand up in a courtroom and say that they have this prior conviction, I've committed a crime. So this is not a shielding. This presents a situation where we're requiring the courts to expunge something, and I don't know how they're going to be able to check to see whether or not the person's committed another crime in between, and therefore cannot get a case expunged. There's nothing there. It just says automatically expunged. It just goes away. 10-110, which is the crimes, the guilty findings, there you set up a procedure for a consideration of expungement that's a lot more than just you haven't done anything in the last 7 years or 10 years or whatever the time frame is here. You have to have, you're eligible if, or you're entitled, I should say. If you've not committed another crime since then, you're entitled, and the victim is entitled to be notified of the existence of the petition for expungement. The state's entitled to be notified of the petition for expungement. We have an opportunity to object. This doesn't give us that. It has totally cut out the state and totally cut out the victim for any input on whether an expungement occurs. It just occurs. You can actually find scenarios here where somebody could have something automatically expunged and they're still in jail because this is from the disposition. So they could still be in jail for this and it gets expunged for their record or on probation. The Maryland State Attorneys Association is opposed to this legislation.
Chair, so sounds like your testimony is in conflict with the testimony of Mr. Galley and others earlier. I'm not sure how to reconcile the two, except maybe at a work group to try to, what you're saying is you wouldn't mind this bill if it were merely shielding, but you're upset that it is actually completely expunging the material from the records. Is that what you're saying?
No, not entirely. I think even shielding would be problematic here because let's say the person has this one conviction and then they commit 5 more crimes in the next 7 years. This automatically, if it is just shielding, it automatically shields that. And that doesn't make any sense.
But it doesn't shield it from the judge. So when they're going to court for the next crime and are convicted and the judge is about to impose penalties, the judge will be able to see that they were previously convicted of the same crime.
If it's a true, just public case search or shielding, you're right.
Well, that's, so I see, I'm looking at top of page 2, and there are 2 provisions. It says expunge means 1, remove all references to a specified criminal case from the central repository. That's what you were referring to.
Yes.
And 2, remove from public view all electronic court records relating to the case.
Right.
So if we left part 2 there but took out part 1 to remove the language about removing it from the central repository, but left in the language that remove it from public view, would that satisfy your concern?
Well, that second one says is more than just public view. I mean, it's all electronic court records relating to the case. Actually, I take that back. It does say remove from public view. I apologize.
Right.
If it is, I mean, I think it's more applicable to the shielding statutes that exist already. I don't remember the exact wording that exists in those, but that is public case search. There's actually a secure case search that's accessible to us and some others in the law enforcement system where that would still be visible. But the bottom line is it still doesn't make any sense to me that somebody, even to the public, if they've committed 5 more crimes since then, Why is it that the public shouldn't know about this one?
Okay. I think we can work on this and get it right, but I take your point.
Understood.
Thank you.
Seeing no further questions from the committee, thank you very much.
Thank you.
Excellent. With that, that'll conclude the hearing for Senate Bill 398. We'll now move on to Senate Bill 410. Senator Waltrager.
Thank you, Mr. Chairman. This hearing is sponsored only because we passed this bill last year. If you recall from the testimony related to mail theft is traditionally a federal crime because the mail is controlled and managed by the federal government. But what we see and what we heard from the U.S. Attorney's Office last year is that they are overwhelmed, and they generally reserve the prosecution of federal mail crime offenses where the loss is 7 figures. In other words, more than $1 million. Our communities have been really impacted by mail theft in the past few years, both theft from mail boxes as well as theft from the blue boxes, the postal boxes, where someone somehow obtains, usually fraudulently, a skeleton key that allows them to open up the blue boxes and steal mail directly from mail receptacles. And so a lot of states are responding to this by passing their own state-level mail theft crime so that what the U.S. Attorney's Office cannot prosecute because of resource issues can be prosecuted at the local level. So this isn't a porch piracy kind of bill. We have other laws that deal with people stealing Amazon packages and the like. This is specific to theft of the United States mail and the impact that it's had on our community. Last thing on this, the impact is especially pronounced on our seniors and vulnerable adults. Most of my payments are done automatically. They come directly out of my bank account. Most seniors who have less experience with that technology still send checks, physical checks, to their creditors, including, if their mortgage is paid off, their property taxes. And so what you see is mail theft is directly impacting our seniors because they are the ones who write checks. And when those checks are stolen and washed, seniors are overwhelmingly impacted by that. So like I said, we passed this bill last year, I believe, in the same form in which it is in front of you. And I'd ask for a favorable report once again this year.
Questions from the committee?
Thank you,
Seeing
Mr.
none,
Chairman.
thank you very much. All right, with that, that'll conclude the hearing for Senate Bill 410. We'll now move on to Senator Charles, Senate Bill 525.
Thank you, Mr. Chair. Chair Smith, Vice Chair, and members of the Distinguished Judicial Proceedings Committee. For the record, I'm Senator Nick Charles, testifying in support of Senate Bill 525, which requires each county to establish a program allowing members of the public to submit video evidence of illegal dumping or littering violations and receive half of the total fines collected if their evidence leads to a conviction. As we all know, we're dealing with a huge budget crisis right now, and I think this is the $15 million answer to at least get us some resources into our coffers, but also get our community engaged to participate in this as well. Recently, for Earth Day, I had my children and I, along with a bunch of other community leaders, did a massive cleanup along Marlboro Pike. And on this cleanup, we picked up about 70 to 80 bags worth of trash. And then we got in the car and got on 495 about to head to my dad's house. And the first thing that happened, as soon as we get on 495, is the vehicle right in front of us chucked out a bag of trash, a McDonald's bag, right out the car. We just did all of this cleanup, and somebody chucked the bag right out the car in front of my children. And my kids said, "We just did all this cleanup, Dad. What can we do?" The reality is there's nothing that we could do. You try to call the troopers. You can't give somebody a tag because you don't have enough evidence to prove that this person just threw something out of the vehicle. What this bill does is it allows for now moving forward, a lot of our municipalities, our counties are in a position where they can enable themselves to have a program where they can accept video footage directly from individuals. And in some jurisdictions like Prince George's County, there's fines that go up to $1,500 or $1,000 fines for littering and dumping. If you get that $1,000 fine, somebody submits a video and they capture you doing this, the person who submitted the video, that's $500 that goes to the person that submitted the video, and another $500 that goes towards the agency who's handling this. In California, they generated $60 billion in revenue doing this. $60 billion. Within the very first month of implementing a program like this in the state of Florida, they generated over $300,000 in the very first month. We have to truly take proactive measures in our own hands if we want to keep our communities clean. And right now, there are not enough police officers to police folks when it comes to littering. There's not enough staff with Maryland Department of Transportation, not enough staff with our Department of Public Works and Transportation agencies within Prince George's or any of our agencies across the state of Maryland. So this bill would allow for us to put things in the hands of our residents. The folks who are out on the streets who are driving around and they see these infractions happening all the time. And so a lot of you guys have a letter that I brought around, and this is a letter of support coming from Maryland Department of Transportation. What this bill does, like I said, it helps change the narrative. It keeps our communities clean. And it just changes the way people perceive Maryland. A lot of folks think you can come into our communities, disrespect our neighborhoods, disrespect our streets. This holds folks accountable. So I'm asking that I can get all of your support in support of this particular bill, and I'm willing to accept questions.
Thank you very much, Senator. Senator Sidmore has a question. It's an interesting intersection between your bill and this bill.
I'm glad that you recognize, and again, in my testimony the other day, you were not here.
Yes, I remember. I came to your office and we spoke about
That's
it.
That's right. I alluded to this bill because, again, I think this is a reimagining of how we do things. So I fully support this. I mean, I could imagine that you have a number of people who may. I mean, it's a great way for individuals to make some money and a great way to keep our roads clean, and another great way to now have law enforcement look to other things rather than looking for littering. So I appreciate you putting this in and doing the research to let us know that other states are doing this, and it's a success.
And it's huge. So we're spending $11.6 to $15 million annually in the Department of Transportation, MDOT, just to keep our roads clean. $11.6 to $15 million, which is crazy. And you look at California and they raised over $60 billion. So with this budget deficit we're dealing with, this is a slam dunk to start raising some resources for our jurisdiction.
I think it's imaginative and great.
$60 billion.
You're up. No. Let me say this. My council person is afraid of my wife, who must call and scream every week about certain intersections being filled with trash. So if I don't vote for this bill, I probably won't be able to go home for a while. So you've got my vote, and I think that we need the revenue, don't you?
Yes, sir. I do believe it. Just like you with your wife, my mother lives on one side of my district, and then my father lives on the other side of the district. And I get screaming calls from Upper Marlboro to Clinton saying, when are y'all going to fix these roads and clean these roads? And I hold a monthly meeting with MDOT and DPWT and the police department and WSSC. All of the folks come together, and we address this issue every single month. I allow for folks to bring their grievances, and most of the time it's trash all up and down our roads. And so this puts us in a very good position to have eyes on the ground rather than employing our police officers, our Department of Public Works folks, and our State Department of Transportation to do all of this work for us.
I don't know if there's a correlation, but when I went home and told my wife I co-sponsored this bill, I had a steak dinner the next day.
Oh, man.
So God bless you, son. God bless you.
I'll do another one like this for you, too.
Thank you, Mr. Chair. So $60 billion in California, that's a lot of trash.
It's a lot of trash.
A lot of trash.
A lot of trash.
Or is their fines pretty excessive?
They probably have excessive fines.
This is my shock face.
Yeah.
So I was just curious, how would this be set up? Can we get paid through Venmo?
For you, we can set up Venmo. But listen,
Senator, I apologize. I'm just joking. I'm sorry. So in seriousness, though, I think you have just finally brought forward the one piece of MDOT camera legislation that I can get behind, the trashy camera bill. I say we get it going. We'll get them back in here, put cameras everywhere for these trashy violators, and start sending them notices to the registered owner.
To the registered owner of the vehicle,
Yeah.
Exactly. So,
and then give half to you.
To you. You can go ahead and.
I might open that business. I think it's a great idea. I think that might be my retirement job. So thank you.
So one of
I don't
one
even
of
know
the
what's happening
things.
right now, but
One of the.
what's going on?
If you look at.
All right.
What I'll say is when you look at a lot of the. When you look at a lot of the Uber drivers, and they have the GoPro cameras already in their vehicles that's capturing what's happening outside and also inside of their vehicles. You know, those GoPro cameras, you put a GoPro camera in your car, you capture somebody dumping. Had I had a GoPro camera in my car the day the guy chucked trash out in front of me and my children, we could have submitted this, and then like it goes towards the same way if you run through a red light, it goes towards the registered vehicle, and it'll go directly to the registered vehicle if the jurisdiction sends that to that person. So, you know, I'm hoping I get you all support. I think this is a huge bill that's going to make a big difference in keeping our communities clean and raising some revenue at the same time.
I've never seen the senators so chatty. Everyone's all chatty and everything. What's going on?
Trashy communication.
This is a side hustle with your GoPro. You get your Tesla with Sentry mode going on, you know, record everything. This is all happening while Senator Love is out of the. She's gonna like, where's the data go? How long are the images gonna be captured for?
And Mr. Chair, I was waiting. I was hoping Senator Love was going to be here.
She's doing her job representing JPR and Finance. But all right. Let's call this hearing to an end before Senator Love gets back. All right. All right. Questions? Seriously, any more questions? All right. Thank you very much. Thank you, Senator. All right. With that, that'll conclude the hearing for Senate Bill 525. We'll now move on to Senator James with Senate Bill 545. Mr. Sam Deschanel, welcome.
Yes, thank you, Chair Smith, for the opportunity to present the bill. This legislation is very important to Senator James, so she does regret that she's not able to be here. For the record, my name is Samuel Deschanel. I'm Legislative Director for Senator James, here to present Senate Bill 545. Over the last 15 years or so, there's been three major trends that have occurred to justify and indeed necessitate that Maryland pass Senate Bill 545. First, the victims of child pornography are getting younger and much younger. Meaning these are children who are prepubescent, toddlers, or infants. Second, because of how young these victims are, the hideous acts against them that we're seeing are always violent and can even go beyond comprehension of what a normal person can comprehend. Third, advances in technology, computers, internet, and data storage means that the perpetrators receive more and store not just hundreds, but often thousands of images, and more often these images are actually videos and films that will be captured in the new section 11208.2 under this bill. So to begin to address these issues, Senate Bill 545 does three things. One, it increases the penalty for possession of 100 or more images of child pornography. Two, The bill increases the penalty for child pornography when the child victim is under the age of 13. And 3, the bill treats each video, film, or other similar moving depictions as equaling 20 images. There's now a constant escalation of these negative trends because a tipping point has been reached. Demand is fueling supply, and more supply is desensitizing the perpetrators, who then internalize what they're seeing as normal, and they thus demand even more shocking and more craven images. The following highlights further demonstrate the need for this legislation. From 2007 to 2011, alone, just the total images and videos reviewed by law enforcement went from 5 million up to 22 million. And 85% of the men arrested for possession and/or distribution of child pornography are also committed a hands-on offense against a child. At the same time, the consumers of child pornography now possess increasing numbers of images. According to federal authorities in 2019, the median number of images was 4,265, but with many offenders possessing even millions. In cases across the country, state law enforcement officials repeatedly see typical cases involving 20,000 to 50,000 images. Plenty of cases are involving even over 100,000. According to the federal sentencing of child pornography report for 2019, over half, 52.2%, of child pornography offenses included images or videos of infants and toddlers, while nearly every single offense, that's 99.4%, included prepubescent children. That the incredibly young are an ever-increasing and often dominant part of today's child pornography is evident in every state for which we could find reporting. A list of some of the sources is included in the bill file for, at the end of this testimony. Currently at the federal level, there can be sentence enhancements based on the age of the victim, if they're under 14, based on the brutality of the image, if it's sadistic or masochistic, and for the number of images. Additionally, a number of states also have increased penalties for the number of images and the age of the victim. To keep up with the technological capabilities and ever-increasing storage capacity, these same states now allow criminal complaints to describe the vast number of images in batches to make the early process more efficient and less unwieldy for law enforcement. Maryland's child pornography statute has not been updated in this area since at least 2014 and possibly as far back as 2009. In either event, Maryland is not caught up with the realities on the ground, and our child pornography laws are not aligned with our recognition and significant policy improvements in protecting children from abuse, assaults, trafficking, trafficking, all of which are the essential crimes behind the explosion in numbers, the even more hideously perverted and brutal images that have taken hold in the modern world of child pornography. As you'll find in your bill file a report from the organization We Need to Do Better, which is the country's leading fighting sex trafficking organization. As one of the experts in that organization stated, we don't say the words child pornography because the accurate description is images of sexual assault on a child. Senate Bill 545 is the first step in acknowledging this truth in Maryland. Thank you for your time and ask for a favorable report.
Excellent. Thank you very much. Questions from the committee? I know that we have Mr. Potashnik is here to answer questions, technical questions, but I assume we'll just engage the senator, yourself, and Mr. Potashnik as we workshop the bill moving through session. But questions from the committee? All right. Hey, thank you very much.
Thank you very much. Excellent. I appreciate it.
That'll yeah, hope she gets well soon. That'll conclude the hearing for Senate Bill 545. We'll now move on to Senate Bill 443 and 444. Yeah, come on. All right, good evening. For the record, Senator Smith here to introduce Senate Bill 443, which is a bill that this committee has seen and then also passed last year. It went into the House, and then I think what we did is we attached some other relevant gun bills onto this bill, and it got jammed up. And so this year, my goal is to keep this clean. And what this does very simply is that it classifies trafficking of firearms instead of a misdemeanor, which it is right now, as a felony. And a couple of, I think, startling statistics from Maryland. We obviously have some of the best gun safety laws in the country on the books, but we still have an unacceptable rate of gun deaths. And earlier in a rally, we had, the Moms Demand Action. We're down here. We talked about the disparities for not only gun violence is the leading cause of death for adolescents and youth, but also has a disparate impact on people of color, particularly African Americans. And according to a recent study from Giffords Law Center to Prevent Gun Violence, Maryland has the highest rate of out-of-state illegal gun imports, according to accounting for 2/3 of all the gun crimes in the state. That number is also reflected in Baltimore City, that 2/3 of those firearms are actually from out-of-state that are found in gun crimes. So what this bill does, very simply, it classifies it as a felony instead of a misdemeanor. You'll have an interlineated copy of an amendment, which is somewhat technical in nature, but has the policy impact. So although we're reclassifying it as a felony, it still would still carry with it with that 3-year statute of limitations. What this does is pulls that out of that list of 3-year statute of limitations and makes it as a felony. So there's no statute of limitations on a felony. This is an underutilized portion of our statute. And I think one reason is because it's harder to prove, but also because there's a shorter period statute of limitations. By making it a felony, you erase that barrier to investigation, and hopefully we'll have more prosecutions under the statute for gun trafficking of illegal firearms into our state. I'll just, for comparison, like it's so. I mean, I know that felonies are significant, but drug trafficking in Maryland is a felony, and obviously, illegal firearms in the wrong hands are inherently dangerous, and I think that somewhat of a value statement, but also enables our law enforcement agencies to better investigate and prosecute illegal guns coming to our state. And so with that, I'd ask the committee for a favorable report. I'll turn it over to you.
Thanks, Senator.
Thanks.
Good evening, members of the committee. My name is Adam Rosenberg. I am the Vice President of Violence Intervention and Prevention at Lifebridge Health, a regional health system in the Baltimore area, as well as being the Executive Director of our Center for Hope, which focuses on all forms of violence and our ability to respond as a public health cause here that violence is. Senator, thank you for reintroducing this bill. I wanted to, you have a copy of my testimony there. I wanted to reinforce Lifebridge Health's commitment to this issue there. Our CEO, Neil Meltzer, has realized his position as a public health leader in Maryland is one to be able to do all that we can do to prevent avoidable gun deaths. The flow of illegal firearms into Maryland, of which have contributed to over 500,000 crimes in Maryland over the last several years, is insurmountable. I'm joined here with my colleague Brian Deffa behind me, the Chief Marketing Officer at Lifebridge Health, as we are so committed to this that we've launched our own campaign, Stop the Iron Pipeline. You can go to stoptheironpipeline.org. And you'll see the collateral on television and on video, but it underscores the point that, and I think this is one of these areas that we agree on there, that there are legal ways to get guns and to own guns in Maryland, but the flow of illegal firearms in Maryland directly contributes to the statistics that the senator shared there. Avoidable child deaths, it contributes to suicide. Guns are the most effective form of suicide there. Guns lead as a force multiplier for domestic violence. And by having guns illegally here in Maryland there, it just increases the preponderance of death. Most notably, in our own community in Park Heights, we suffered the avoidable death of a 10-year-old child last week who picked up her grandmother's gun, and the grandmother was not permitted to have a firearm there, but that weapon was an illegal firearm that came from North Carolina there. These guns traffic up and down the I-95 corridor, and this is one of those great efforts to be able to recognize this as a felony and prevent future gun deaths from happening. And I appreciate the support and ask for a favorable ruling. Thank you, Senator. Thank you, committee.
Selfless plug here, though. The Iron Pipeline is actually, definitely check that out. That's fantastic work and analysis, and it's something that I think more of us need to pay attention to, especially being just nested here in the Eastern Seaboard. Just really great work. I just wanted to say it's a fantastic resource. So, selfless plug. Okay, it's not really a plug for me, but it's good plug for good work. All right. Oh, can you come on this side? Oh, Oh, yeah. Are you going to do unfavorable or favorable on this? Are you on this one or next one?
Favorable on
443. Okay, yeah.
Come on up. Is that the one we're on?
I think, no, the next one.
The next one. Okay, let's do it.
It could be unfavorable on this one.
444, are you coming on 444?
443.
Okay, you want to testify? Oh, okay, we'll come up with that. Let's do, I think that's right.
Yep, I think that's what we got. All right, Mr. Jocelyn, you are up. Testifying in favor.
This is so awkward. I'm used to being here and testifying, telling the chairman that he has a terrible bill and it goes too far. I find myself testifying in support of 443, but it doesn't go far enough. We agree that trafficking is a problem. I personally don't use special interest statistics for trafficking. I use the ATF numbers. I find they're more accurate, and they're also antiseptic. However, we believe that in addition to making this a felony, we should put a 5-year minimum penalty on it, and we should consider every trafficked firearm to be an individual offense. This is a very serious problem, and we believe that unless we really get serious and put some teeth in the bill, we're really not going to accomplish what we're trying to do. So, Senator, I'm with you on this one. I can't be with you on 444, but I'm with you on this one.
I'll take half. I'll take half a loaf when I can get it. There you go. I appreciate that. Sure. So what? Oh, yeah, final. All right. For the record, Senator Smith here to introduce Senate Bill 444. So actually, I first became aware of this problem through an article that came out last year. It really highlighted things that happened in Michigan, where law enforcement agencies, FFLs, were partnering with charitable organizations, churches, and the like to conduct gun buybacks. And when they would take those gun buybacks, the frame and the receiver, the regulated portion of the firearm would be destroyed, but the other component parts would not. And there was a private entity in which they contracted, in which those component parts were then making their way back into the marketplace, and sometimes subsequently making their way into guns that were found in crime scenes. So what this bill seeks to do is it doesn't make a judgment, it doesn't a value assignment on whether we should have gun buybacks, whether they're effective, and where and how, or the time, place, and manner restrictions of how gun buybacks happen. It simply says that if you do conduct a gun buyback, that you have to destroy you have to completely obliterate the entire firearm, not just the regulated pieces, but every component part. The reason you'll see that none of the police departments around the state have come, or law enforcement agencies have come in opposition, but just information, is because most of the folks generally strive to do this anyway, to make sure that they destroy all the component parts. I had information last year. We passed this bill last year. Again, we attached another bill to it, so it got jammed up in the House. Prince George's County, Anne Arundel County, Baltimore City, Montgomery County, Rockville Police Department have all conducted gun buybacks within the last 5 years. They have, I'm in receipt of an amendment, which I think is also in your voting packet, or not your voting packet, but in your packet, which essentially says that if a firearm that is turned in is is a crime gun or subject to an investigation, that they can hold on to that for the duration of that investigation. Apart from that, that is the sum and substance of the bill. And with that, I'd ask the committee for a favorable report. Oh,
I guess there were not, yeah, there were no, we're in support of it, so. Yeah. That's okay, kind of right.
Thank you, Mr. Chair, and Mr. Chair, thank you. My only question is there any provision for, in a gun back program, you have some form of an antique gun that would have some kind of significance for a museum or something to that effect? No,
so we talked about this for like antiques or curios, so unregulated firearms. There is not a provision for that. You know, I'm sure we could work I'm sure something could be worked in. I don't know how that would put a significant burden on the agencies conducting the buybacks, but I'm sure we could work on some sort of language. I'm also not certain that most of these unregulated curios and relics are being turned in to buybacks, but happy to work with you
The
on
only
that.
thing that I bring up is maybe my father was a collector, and now I am not, or my grandson now is not. He is, maybe he lives in a county really closer to the metropolitan area, and he doesn't believe that anymore. So I think there's an opportunity there. Consider it. So thank you.
I think it makes sense. All right. Hey, thanks, Len.
Senate Bill 444. And that concludes our hearings for the day. Take care, everyone.